And we should be good to go.
Oh, you know what I need to get? I forgot my right to know script. Hold on.
Okay.
I'm like, I usually have everything right in front of me and I didn't take it out.
Want me to do the right to know? I'm ready.
No, I got it. I usually have it and I put it away instead of keeping it out. And sorry, I apologize. That's not a good way to get started.
From yesterday, but
We're good.
that's the word.
Okay, sorry, everyone. I apologize. I just didn't have it in front of me. Good afternoon on this wonderful snowy Tuesday. Just so everyone knows, the groundhog did see his shadow. So we're going to have 6 more weeks of winter. Welcome, everyone. I am Senator Sharon Carson from District 14. Today, we will be holding a meeting of the Senate Judiciary Committee. Before we get started, I'll read through a checklist to ensure that the meeting we are holding is in compliance with the right to know law. As chair of the Senate Judiciary Committee, I find that due to the state of emergency declared by the governor as a result of the COVID-19 pandemic and in accordance with the governor's emergency order number 12, pursuant to Executive Order 2020-04 and its extensions, this public body is authorized to meet electronically. Please note that there is no physical location to observe and listen contemporaneously to this meeting, which was authorized pursuant to the governor's emergency order. In accordance with the emergency order, I am confirming that 1, we are providing public access to the meeting by telephone with additional access possible by video and other electronic means. We are utilizing Zoom for this electronic meeting. All members of the committee and selective legislative staff have the ability to communicate contemporaneously in this meeting through this platform, and the public has access to contemporaneously watch and/or listen to the meeting on Zoom or YouTube and via phone by following the directions and links provided on the General Court website. 2, we have provided public notice of the necessary information for accessing the meeting in the Senate calendar. 3, we are providing a mechanism for the public to alert the public body during the meeting if there are problems with access. If anyone has a problem, please email remotesenate@leg.state.nh.us or call area code 603-271-6931. 4, in the event the public is unable to access the meeting will be adjourned and rescheduled. 5, please note that all votes taken during this meeting shall be done by roll call vote. So, and number 6, finally, let's start the meeting by taking roll call attendance. When each member states their presence, please also state where you are and if anyone else is in the room with you during this meeting, which is required under the right to know law. I will call the roll. Senator Gannon?
Senator Bill Gannon, I'm in Sandown, New Hampshire. I have 2 Timberlane Zooming students who couldn't find the time to help their father and mother shovel, but they may or may not walk through it. Thank you.
Thank you. Senator French?
Yeah, Harold French, Canterbury, New Hampshire, Senator for District 7 in my home. Jane is also here, but she's in the far east wing of the palace.
Okay. Senator Khan?
Present in Keene, on my own. My wife is elsewhere in the house.
Senator Whitley?
Senator Whitley here in my house in Hopkinton. I am alone in the room, but my family is in the house. And I have just actually asked my son to go outside and shovel. So hopefully he will do that soon.
And Senator Carson? I'm Senator Carson. I am at my home in Londonderry, and my daughter is in the room with us. Okay, let's get started. I'm going to turn the gavel over to Senator Gannon to open the public hearing on Senate Bill 93.
Thank you, Senator Carson. Okay, we're going to start off with the Honorable Sharon Carson to start off Senate Bill number 93 FN.
Good afternoon, Mr. Chairman, and thank you. For the record, my name is Sharon Carson. I have the pleasure of representing Senate District 14, which is comprised of the towns of Auburn, Londonderry, and Hudson. And I have for your consideration this afternoon, Senate Bill 93 FN. This bill clarifies that adoption rather than the termination of parental rights is a potential permanency plan objective. It also clarifies the timing of the 10-month permanency hearing, specifies other circumstances for when a subsequent permanency hearing may be conducted. It also allows for an earlier permanency hearing. It provides for cases where the parents are in compliance, but the unique needs of the child preventive unification. And it clarifies that the court can modify a permanency plan by agreement at a post-permanency hearing. This bill is a request of the New Hampshire Model Court Project and the Legislative Study Committee established in 2019. I'm just going to leave it right there. So as I testified, this is a request of the Model Court Project. And so I would ask you to hold your questions because we have people here that were very, very involved in this who would be able to answer your questions. Thank you, Mr. Chairman.
Thank you.
Okay,
Any questions for Senator Carson? But which we're holding our questions anyway, so
yes.
moving on. Thank you, Senator.
Okay, thank you. The chair will call Judge Susan Ashley.
Good afternoon.
Good afternoon.
Thank you to the chair and Senator Carson. You can hear me okay?
Yes, we can.
Wonderful. Technology is excellent today. So I appreciate the opportunity to talk briefly about Senate Bill 93. I have provided written testimony and hopefully you've had the opportunity to get that or you will have that available to you because I know we have limited time today. In summary, just to introduce myself, I apologize. I'm Susan Ashley. I'm the Deputy Administrative Judge for the Circuit Court in New Hampshire. And I also am the lead judge for the Model Court Project, which has been in place in New Hampshire for quite a while. I took over for then Judge Gordon when he had been lead judge back in the early 2000s. We have, as a Model Court, worked in drafting this legislation in order to address several issues that relate to permanency for children in abuse and neglect cases that we feel could use statutory correction or updating. And those are delineated throughout the statute, but in summary, they address the specifics of when we can have a permanency hearing. Right now, the statute really only focuses on the majority of times when we do a permanency hearing, which is at the 12-month mark following a finding of abuse or neglect. However, there are other times in which the court either must have a permanency hearing or should have a permanency hearing, and they simply aren't delineated in the statute right now. We do them because, and certainly in one instance, the Supreme Court says we must, and so the fact that there isn't a codification of that is fine, but we think that there should be a clear codification of some of these issues. So the first issue is when there is a need for an extension beyond the 12 months. And right now that does happen in some cases and the court does order those types of extensions, but we would like there to be some clearer guidance and consistency in application of those types of extensions so that there isn't unnecessary delay for permanency for children. Again, there may be a need for it because parents are close to reunifying with their children, but they're not quite there yet, and a little bit more time will help them. But we don't want there to be an unnecessary delay. So some clearer guidance in the statute is something that has been requested across the board from all participants in these types of cases. And so one provision of the statute would provide the parameters under which an extension could be granted, provide a standard for that, and indicate that it's one extension for a period of 90 days. And then if we give that extension, there would be another permanency hearing. So it allows the parents to clearly understand what they need to do at that next hearing in order to hopefully achieve reunification. And if they aren't able to do it after that extension, then we would change the permanency plan to something other than reunification. Typically, adoption through termination of parental rights or potentially guardianship. So that's one area that this statute addresses. Another area really on the opposite end of the spectrum is the idea about having an earlier permanency hearing. There was a study committee that participated in looking at this issue. In 2019, of course, the pandemic did restrict the amount of work they were able to do on that, but there was a full report issued by Judge Gordon, or Representative Gordon was the chair of that committee, and they did look at early permanency hearings. Now, one of the things, one of the case types that prompts this kind of a conversation, those situations in which parents are simply not doing anything on these cases. And it doesn't happen that often, fortunately, that both parents are not doing anything. But if that is the case, this would give the court the opportunity to have an earlier permanency hearing if DCYF can establish that that's necessary under the standard that is set forth in this, excuse me, in this legislation. So there'd need to be some kind of compelling reason to do this earlier and not give the parents the 12-month period of time. And if we did have that early permanency hearing, it doesn't mean that we would move directly toward termination of parental rights at that time. It could be that even scheduling that hearing jumpstarts the parents to comply with a case plan. And maybe that's enough to stave off that next step, and maybe they're able to correct matters in the subsequent time. So it would give the court the discretion as to what to do at that early stage, but at least we'd be evaluating it at an earlier stage. So this proposed legislation covers what we would call or refer to as an earlier permanency hearing in the situations in which that may be appropriate. And then there are a couple of other circumstances in which we do need to schedule a permanency hearing. At the far end of the spectrum of abuse and neglect and termination cases, if that termination petition is denied, case law provides that we must schedule another permanency hearing. And that really isn't spelled out in the statute, so we want to have that codified as well. Also, there are some circumstances in which parents do well enough to be able to reunify, but the case does not close because there are still services that are being provided and there's still a need for child protection to be involved with the family, and things turn south, so to speak, and the child has to be removed from the parent's care. And this is, of course, well down the road, typically after the 12-month mark. So there is an uncertainty as to whether or not DCYF has to file brand new petitions and we start the process all over again, or whether we can have another permanency hearing. And this legislation would provide for that other permanency hearing to revisit the issue and not restart the clock for those children who have already been in out-of-home care for quite a long time at that point. And then the final area, or a final area that this legislation covers, are those circumstances in which the parent at the time of permanency really have complied with the terms of returning the child to their care, which is covered under RSA 169C23. But there are some unique needs of the child that would prohibit that. So perhaps a child is in a treatment program and the family circumstances are such that the child really needs to complete that treatment program before coming back into the family home. Right now, as our system is set up, there really isn't a mechanism to keep that child in that treatment program without continuing the child protection case with the status of an out-of-home placement. So it would provide an opportunity and an allowance for the court to keep the child placed, but still have reunification as the ultimate goal. Ideally, when the child is completed with their treatment, then the child could return home to the parents. But our statute, as worded now, doesn't really allow for that situation in those unique cases. And so the revision to the statute would allow for that, and it would stay a reunification case until and unless someone asks for another permanency hearing, perhaps where they may want to change the permanency plan, for instance, to a guardianship with another relative or to some other permanent plan. So this would allow for that type of a permanency hearing to occur as well. So those are just a few of the areas that are covered in the statutory revision. I know I whizzed through those for you folks, but I know there are probably others who might want to speak, and I'm happy to answer any questions that you have. either during this process or at any time, at any later date, feel free to reach out to me.
Thank you, Judge Ashley. Are there any questions from the committee? Senator Whitley?
Thank you, Madam Chair, and thank you, Judge Ashley, for your work on this bill and then your work in general on behalf of New Hampshire children and families. I'm curious, because I am new to the Judiciary Committee, who's part of the New Hampshire Model Court Project and how did that start?
Sure, thank you. So it actually started New Hampshire was selected as a model court participant back in, I want to say it was mid to late 2000s, and Judge Carbon was instrumental in the initial model court project. So there was some grant funding and there was some technical assistance provided. And then that, of course, went by the wayside after a couple of years, but New Hampshire continued the model court. What it is involved, who's involved in it is really the folks who are engaged in child protection cases. So the model court has representatives from the court, DCYF, CASA and non-CASA guardian ad litems, and parent attorneys. We have Sarah Blodgett, who is the representative for all parent attorneys as judicial counsel, head of judicial counsel, but we also have a couple of parent attorneys. Of course, we don't have an umbrella organization for our parent attorneys, but we do have them as volunteers. And we meet regularly to discuss essentially any and all issues that address permanency and other procedural matters for child protection cases, which have resulted in multiple sets of protocols that have issued through the years. And that's really what is an impetus for this legislation, because we need to circle back to our permanency protocols, which were first written back in 2003 and haven't been revisited and really need to be revisited. They existed before there was even a statutory reference to permanency hearings. So we need to circle back to those, and we would like to have clearer guidance in the statute to be able to do that.
Thank you.
Senator Whitley, I will tell you that the written testimony we received from Judge Ashley on the first page, they do tell you who are the members of the Model Court Project. So you can go down and read each individual's name and see who they represent. Senator French.
Thank you, Madam Chair. Thank you, Judge Ashley. This change of from 12 months to an earlier time for permanency, how early could that become?
That would not happen before the 6-month mark. So we would provide the parents at least 6 months. And when I say 6 months, it's 6 months from the court's finding of abuse or neglect. And that generally happens about 30 days after a petition is filed. So at the time of the 6-month hearing is when DCYF could ask the court to have an early permanency hearing. And then we would schedule it. And we talked at length about that as a multidisciplinary group as to what would be a fair time to have an early permanency hearing, because we know that parents do not always hit the ground running, shall we say, and sometimes there's difficulties in them even accessing the treatment that they need. So we decided upon a 6-month mark. Of course, that certainly is open to others' input.
Great, thank you. Thank
You're
you for testifying today.
Okay, are there any further questions for Judge Ashley from the committee? Seeing none, thank you very much for your time this afternoon, Judge.
Thank you all.
The chair will call Rebecca Ross.
Good afternoon. Thank you, Madam Chair and members of the committee. Thank you for the opportunity to provide testimony today on Senate Bill 293. My name is Rebecca Ross. I'm General Counsel and Legislative Liaison for the Division for Children, Youth, and Families. We are here today in support of Senate Bill 293. As you heard from Judge Ashley, we worked in collaboration with the Model Court Project to put this proposed legislation together, and we believe it provides clarity both to the courts and to the parties on the permanency process and adds flexibility where the circumstances warrant it. We believe it would be limited exceptions on both ends, but that the one-size-fits-all 12-month permanency hearing does not adequately meet the needs of all children and families in New Hampshire, and this would give the courts and the parties the ability to meet the best interest of the children in those outliers. We did participate in the fiscal note process, and given the number of cases that we think this would impact, there would not be a fiscal impact to the department, but it would be critically important to those families where these changes would apply. We think that the high burden for the exceptions would certainly have an impact on limiting that and would be very appropriate in those cases where we are seeking an exception, and would avoid injustice by the undue delay in certain families that we see and we serve through DCYF. It provides critical updates to the terminology that are consistent with our practice. It is consistent with the federal requirements, and would assist all of us in meeting the unique needs of children and families in each case. And I'm happy to take questions at any time.
Sure. Thank you very much, Ms. Ross. Are there any questions from the committee? Okay, seeing none, thank you very much. Margaret, I don't have anyone else who has signed up to speak. Is there anyone in the waiting room who would like to speak?
So if anyone is in the waiting room, you can virtually raise your hand, and if you are calling in by phone, you can press *9. Senator, I do not see anybody with their hand raised.
Okay, then I will go ahead and close the public hearing on Senate Bill 93. I will tell the committee in the packet of information that we did receive from Judge Ashley, there is a proposed amendment, and we will get that amendment drafted, and hopefully we'll have it ready for next week. So, okay. Next, we're going to move on to Senate Bill 95. Seeing that it is, what time is it? 1:22, and it was scheduled for 1:20. I just would like to go ahead and open the public hearing on Senate Bill 95. Would like to inform the public that this is a omnibus bill. And so I'm going to read the different parts of the omnibus bill with the LSR number. Part 1 is LSR 2021-0993, which was filed by Senator Daniels, which authorizes governing bodies of municipalities to have virtual or in-person meetings. Part 2 is LSR 2021-0911, which was filed by Senator Perkins Coca, and it is relative to remote access to meetings under RSA 91A. And finally, Part 3 is LSR number 2021-0167, which was filed by Senator Gray, which is relative to penalties for violation of privacy. So the way that we're going to do this is I'm going to call each senator according to which part they filed the bill and asking them to testify. And then we will ask the members of the public when they speak to identify which part of the bill they are speaking to. Hopefully that will make things a lot easier as we move through the process. So the first person that I am going to call will be Senator Daniels.
Good afternoon, Madam Chair, members of the committee.
Good afternoon, Senator.
For the record, I'm Senator Gary Daniels, representing Senate District 11, comprised of the towns of Amherst, Merrimack, Milford, and Wilton. I appear before you today as the prime sponsor for Senate Bill 95, which is an omnibus legislation relative to remote meetings and penalties for violation of privacy. I will not repeat the parts that the chair just mentioned. However, I will be speaking specifically to Part 1 of the bill relative to authorizing governing bodies of municipalities to have non-emergency virtual meetings. Amid the confusion caused by COVID-19, numerous opportunities have presented themselves. One of those opportunities is for the public to be more involved in local government proceedings. I'm completing my 18th year on the Milford Board of Selectmen. Over that time, rarely have we had more than 5 people from the public attending our regularly scheduled meetings. However, since being forced by the COVID crisis into virtual meetings, the public participation in our meetings has averaged between 40 and 50 people. The participation in virtual school board meetings is even higher, with one approaching 150 participants, far exceeding our attendance at most deliberative sessions. Currently, the statute only allows municipalities to have virtual meetings in cases of emergency, such as we are now having under the governor's executive order. This bill would allow a governing body to place public disclosure and participation at a higher level and authorize that governing body to have a virtual meeting without there being an emergency. The ability to do so benefits the governing body by not having to reschedule its meeting on a day like today, where otherwise that meeting may be canceled for inclement weather. It also benefits the public, where otherwise that meeting, it benefits the public by enabling them to keep current with local government proceedings from the comfort of their homes, allowing them to provide input and questions and otherwise participate in those meetings. Virtual meetings have become a norm over the past year. We ought to take advantage of that opportunity to invite the public to be more involved in local proceedings so that they better understand how their property taxes are being used. This is a win-win for both public officials and the voting public, and I ask for your support of Part 1 of Senate Bill 95. Thank you, Madam Chair.
Thank you very much, Senator. Are there any questions from the committee? Senator French.
Thank you, Madam Chair, and thank you, Senator. Just one quick question. Would this legislation make it possible for municipalities to only have virtual meetings?
If the governing board so chose, it could be. On my board, I would encourage the board to get together so that if people wanted to be there in person from the public, that they could be. But yes, to answer your question, it would allow a board to do that. Although I think there are benefits to having the board together, but also enabling those members who may not be able to make a board meeting because of sickness or out of town or whatever, to be able to participate as a board member during that meeting.
Great, thank you.
Are there any further questions? Senator Khan?
Thank you, Madam Chair. Greetings, Senator Daniels.
Good afternoon.
Senator, the voting part to this is, I guess, hard to envision for me. I applaud the intent to allow boards to have in-person and simultaneously have remote participation through various communication means. But the voting aspect, how do you envision that occurring? From the remote locations, I can imagine the town moderator, the school board moderator, gathering the votes in person. We've all been there, but it's hard to envision then the next process, and maybe you could explain that.
Are you referring to a regular meeting, say, of a select board?
No, a town meeting. So this is just for witnessing a normal meeting. This is not for. It just says a member participating. It's section E for purposes of voting. help me understand section E then.
Oh, Senator,
Page
if I
2,
can,
13.
Senator, if I can interrupt, I think you are looking at part 2. And that was a bill that was filed by Senator Perkins Coca, and we haven't gotten to that part yet. We're still on part 1.
I'm looking at page 2, line 13.
Okay, okay, because you said, okay, let's see. A member participating in a meeting by means described in this paragraph is deemed to be present at the meeting for the purposes of voting. All votes taken during such a meeting shall be done by roll call vote. Is that what you're talking about?
Yes.
Okay, I'm sorry. I thought you were looking in the other section.
Okay, and you said 13. I mean, what we're talking about in a regular meeting, whether it's a school board or selectmen, is doing things exactly as the legislature does it now. And it's exactly as we have done it over the last year, is that when we take votes, they have to be roll call votes, and each one has to individually state their intent. If you're talking about something like a deliberative session, as a member of the governing body, I mean, we just went through that, and we saw that as something that actually would not work out with such a large volume of
Excuse me.
participants. And so we held our deliberative session with social distancing in person at the school. So I'm not saying that all meetings, but I think we can leave it up to the wisdom of the governing body to determine how best to strategically have that meeting. But as far as your, 26 meetings or whatever they have during the year that are just regular meetings, I don't know why we would have to have an emergency to be able to utilize the technology that we've been using for a year now.
May I follow, Madam Chair?
Yes, please.
So you're helping clarify this, and let me ask one more question. I think you'll get there. You've explained the regular meetings of a governing body. Did you intend that these changes were applicable for town meetings, SB1 towns?
I did not envision them being for deliberative session or the voting session under official ballot referendum towns.
Thank you for the clarification.
Okay, are there any further questions from the committee? Okay, seeing none. Thank you very much, Senator Daniels.
Thank you. Have a good afternoon.
Okay, you too. Now we're going to move on to part 2, which is LSR 2021-0911 that was filed by Senator Perkins Coca.
Yes, good afternoon, members of the committee. Thanks for having me. For the record, I'm Senator Rebecca Perkins Quokka from Senate District 21, representing the city of Portsmouth and the towns of Madbury, Lee, Durham, Newington, Newmarket, and Newfields. I'm the prime sponsor of Part 2 of SB 95FN relative to remote access to meetings under RSA 91A. Through Emergency Order 12, Governor Sununu enabled public bodies to continue to meet during the COVID-19 pandemic with the modification of the right to know rules to allow remote meetings. Part 2 of SB 95FN is a codification of that emergency order. All of us have taken part in these remote meetings. We're doing so right now. In addition to ensuring that we stay safe and healthy during the pandemic, remote meetings have also allowed many more people to take part in governmental hearings, as we just heard Senator Daniels testify to. We've seen during public hearings during this session that many more people are able to attend remote Senate hearings than would normally be able to drive to Concord, and we've heard similar testimony from local municipalities. One example was a school board budget hearing in Portsmouth where we had over 90 folks able to tune in and participate. This is not to mention the many more elected officials who have had an avenue to participate without worrying about childcare or needing to travel in our government. Passing Part 2 of SB 95FN will ensure that governments on all levels, city, towns, and the state are able to continue offering expanded access and transparency even after the COVID-19 pandemic and the state of emergency end. I think that Senator Daniels made many great points in support of this bill. I won't repeat them. I will note that there's obviously some differences in language between his section and my section, and I would be happy to discuss with him about which version may make sense. I'd love to hear from those who are here to testify at the public hearing today about what changes make sense to them. And I also have heard that there's a small amendment proposed to my section, which I have not yet had the chance to review. But at this time, I'd love to welcome questions on what I can answer for the committee.
Okay, thank you very much, Senator Perkins Coca. Is there questions from the committee? Senator Whitley?
Thank you, Madam Chair, and thank you, Senator Perkins Coca, for introducing this portion of the bill. I didn't know if you wanted to take some time to actually identify those areas that needed to be resolved between the different parts, or identify for the committee the sections that needed to, work together between Part 1 and Part 2.
Yeah, sure. Thank you for the question, Senator. So I view my proposal as a broader, perhaps more long-term change to Section 91A. I think that it fully embraces the idea that municipalities would have, complete discretion in deciding to hold and virtually meet in this new digital format. I think it addresses, notice requirements. It does not change the methods for voting. And so in some ways it may be broader than what we're ready to do, but I do think it was some foresight drafting on behalf of OLS. I know that the changes made in Senator Daniels' bill are more limited to sections A and B of the existing Section 91A, which I do think address the majority of what would be needed to switch to virtual meetings. So I don't see them as huge discrepancies, but thanks for the question.
Are there any further questions? Okay, seeing none, thank you, Senator, for, Senator Khan, did you have a question?
It is that observation. Thank you, Madam Chair, and Representative Senator Perkins Coca. I wanted to just feel that these are amending the same sections of the statute, and it probably would be helpful for the committee to see this amended and brought back together. Do you agree?
I do, and I don't know if Senator Daniels is still on the line, but I'm more than happy to reach out to him and have that conversation. I did not realize we had two bills that were so strikingly similar, so certainly happy to do that.
Thank you, Madam Chair.
Okay, thank you. Before you go, Senator Perkins Coca, you had mentioned that there was a proposed amendment. We did receive an amendment from the New Hampshire Municipal Association, and I will ask our committee secretary to send you a copy of that so you can see it for the proposed changes. Okay?
Okay. Yep, that would be wonderful, and I'm happy to work with them too. So I'll do my best to lead that effort and get some language back to you guys.
Thank you very much, Senator. We really appreciate your testimony this afternoon.
Yep, thank you very much.
So next we're going to move to Part 3, which is LSR 2021-0167, which was filed by Senator Gray. This is relative to penalties for the violation of privacy, and we're going to identify Senator Gray.
So it looks like I have to promote Senator Gray to a panelist to let him in.
I think I'm able to be heard now.
Yes, we can hear you, Senator Gray. Welcome.
Thank you.
Part 3 of this bill is a bill that I have submitted in the past that went to study, but was not enacted. It was at the request of the chief of police in Somersworth and Rochester and the county attorney in Stratford County, Mr. Velarde. It has to do with privacy. And first of all, let me go to RSA 644-9 and say that parts 1 through 4, which this references, deal with, in one part, recording of people, being able to transmit images, etc., by any device, amplifying, broadcasting, transmitting images, sounds of private body parts, including genitalia, buttocks, female breasts, and person's body underneath person's clothing. And the problem is that the penalty is Class A misdemeanor. If I were to record you, just your voice, unlawfully, that would not be a misdemeanor. But I can record other things about you, and it is a misdemeanor. Now, the testimony 2 years ago when this bill was submitted last had to do with must and shall, okay? And we have changed the bill so that it says that they may be charged with a Class B felony. I believe that that is appropriate. There is problems that generated this in Stratford County in trying to prosecute an offender for multiple offenses, and the penalties prescribed under Class A misdemeanor were not deterring this person from committing those acts. I'm sure that any of us are very sensitive to images that would be involved in 644-9. Certainly would like to work with the committee if you have any questions. But again, we need to protect the individuals who have been subject to people placing cameras in public places, people recording you through the windows of your houses, people who, walking down the street, have someone with a camera on their shoe, which has been an offense before. We need to protect those people. We need that the punishment for those offense, if it is a person who is a repeat offender, has the opportunity to be charged with a felony. And I'd be happy to answer any questions.
Thank you very much for your testimony this afternoon, Senator. Senator French has a question.
Thank you, Madam Chair. And thank you, Senator, for taking my question. I can't remember from last time, but what was a Class B felony maximum sentence?
I would go to my friends on the Judiciary Committee and ask them, because they would know much better than I.
My friends here, let me see, Sharon, Bill,
It's 3.5 to 7 years.
3.5 to 7. That's what I thought it was. Thank you.
Are there any further questions? Okay. Seeing none, thank you very much, Senator Gray.
Welcome.
Okay, Margaret, I believe we have Cordell Johnston would like to testify.
Thank you, Madam Chair, and good afternoon, everyone. Cordell Johnston, representing New Hampshire Municipal Association, and I'm speaking in support of parts 1 and 2 of the bill. We have no position on part 3. You heard a good explanation from Senators Daniels and Perkins Cuoca about the benefits of public bodies being able to meet remotely. And I also know that the committee received an email from the town administrator in Durham, which sets out in some detail the many benefits that, and I fully support what he's said in that message. And we've heard several comments from many towns and cities around the state about how helpful this has been and how it's increased participation. So we fully support that effort. As has been discussed, there is a difference between what Senator Daniels put in and what Senator Perkins Cuoca put in, and it's actually a pretty big difference. I'm not sure that that part one actually accomplishes entirely what Senator Daniels wanted it to, because under part one, what it allows, it allows any member of the public body to participate remotely, but it still requires that there be a physical location for the meeting. And it still requires that there be a physical location where the public can come and listen to what's going on. So in theory, you could just have a room at the town hall where there are no members of the selectmen present, but the public can come and listen to the meeting. I don't think that's what is intended. But and part two accomplishes allowing a fully virtual meeting where there doesn't have to be a physical location, and the public is able to watch and listen to the meeting via Zoom or some other by telephone or Zoom or some other platform. So, and we could support part one or part two. It's just that part two goes further and provides that much more flexibility. The amendment proposed, and I did just send it to Senator Perkins Cuoca, and I apologize. I should have sent it to her or copied her on the amendment when I sent it to the committee. It's fairly minimal, and I don't know whether you have it in front of you, but in part two on page 3, it sets out the requirements for a virtual meeting. It says a physical location is not required for any meeting if it complies with the provisions of this paragraph. And then B and C require that public access be provided by phone or other electronic means, and that there be information about how to access the meeting telephonically. I think the intent there is to require those things only in the situation where there is no physical location for the meeting. If there is a physical location, traditional selectmen's or city council meeting at town or city hall, and I don't think you want to require the municipality to be providing that electronic access. We'd just be going back to the way we used to have meetings before the pandemic. So that's the purpose of that fairly minor amendment. The one other thing, as I was listening, I heard Senator Khan raise the question about town meetings, and certainly I don't think it's anyone's intent, and I don't know how, at least with current technology, you could hold a town meeting entirely remotely. It's I don't think it can work. That issue has come up. We've had that question from a number of towns, and our answer is you can't do it. But 91A does technically apply to a town meeting, so you might want to amend the bill just to make it clear that you can't have a virtual town meeting. At least, maybe that will change in a few years, but at least for now, I think you may want to make that clear. And that's all I have. I'd be happy to answer questions.
Okay, thank you very much for your testimony, Mr. Johnston. Are there questions from the committee? Senator Gannon?
Yep. Thank you for coming on today, Cordell. After COVID, hopefully sooner than later, aren't we going to lose something? I've been on planning boards, and first of all, I don't see the people. I see a lot of people come there, and they can appreciate it more. They can see the blueprints. If you have it, if they can decide to be fully remote, aren't we going to lose some part of our old New Hampshire charm and having people participate in person? Isn't there a loss there?
I'm afraid there probably is, and I'm not, as Senator Daniels said, I would not necessarily recommend that every public body do this. If I were, and I'm not currently on any local boards, but if I were a selectman or a planning board member, once the health threat passes, I would want to have our meetings in person. But I would like the ability to let people participate remotely, whether it's a senior who has trouble getting there, or there's a weather issue, or someone's traveling and wants to be able to participate. So I think it's good to have the ability to do it, but I wouldn't necessarily encourage that it be done all the time.
Thank you.
Are there any further questions for Mr. Johnston? Senator Whitley.
Thank you, Madam Chair, and thank you, Attorney Johnson. Just to sort of follow up to that, to follow up to Senator Gannon's question, do you think that the current version of the bill sort of retains that flexibility if governing bodies want to continue to meet in person?
Oh, sure. Yeah, if you go with part two or part one, that ability certainly is there. And there are towns that that don't have the best broadband, where they've had trouble meeting remotely, and so certainly some of them are not going to be going to remote meetings anytime soon. But yeah, the ability to meet in person definitely would still be there.
Thank you.
Are there any further questions? Senator Khan.
Thank you, Madam Chair. Mr. Johnson, thanks for being here. I wanted to just clarify, we are using, though, remote virtual town meeting procedures currently, right?
There's a bill that enables towns to have a form of virtual town meeting. It's what we call the HB 1129 process. It's not really the way town meetings are held, but it's kind of a sort of an emergency stopgap measure to enable towns to get their meetings done during the pandemic. Yes.
Madam Chair, that's all I wanted to clarify from Mr. Johnson's testimony. Thank you.
Thank you very much, Senator. Are there any further questions? Mr. Johnston, I've been thinking about this as we've been talking, and a lot of communities have cable access, and they will show a meeting, say, of the planning board or the school board or any other board as it's actually happening live. Do you think that there might be a way to open that up for the public to address while they're having an actual in-person meeting that's being broadcast?
Possibly. Technology is not my strong suit.
Okay.
But I mean, I do know for a while the select board in my town was having in-person meetings. This was in the summer when the numbers were relatively low and it was safe to have an in-person meeting. But they were still doing it over Zoom, so the selectmen were present in the room.
Okay.
Could participate via Zoom if they wanted to ask questions or offer comments. So there certainly are ways to do that. I don't know whether it's cable TV or Zoom or probably several other options too.
Okay, so thank you. And just to follow up with that, do you think that the proposed legislation would allow something like that to happen?
I think something like that can already happen. Under current law, setting aside the governor's emergency order, under current law, you have to have a quorum of the public body physically present. But you can also, you always have the option, if you want, to broadcast that and have two-way communication with the public if you have the interest and the technology to do that. That's currently allowed. What's not currently allowed is to have all of the members participating remotely.
Okay, thank you very much for your questions this afternoon. We appreciate your testimony.
Thank you.
Okay, Margaret, are there members of the public that would like to speak to this bill?
So if you can virtually raise your hand, and if you are on a phone, you can press *9. Senator Carson, I do not see anybody else.
Okay, we're going to go ahead and close the public hearing on Senate Bill 95. Okay. Next, we are going to go ahead and open the public hearing on Senate Bill 92 and recognize the prime sponsor, Senator Bradley.
Good afternoon, Madam Chair and members of the committee. For the record, Jeb Bradley, Senate District 3, and pleased to be here as the sponsor of Senate Bill 92. I want to start out by thanking the various co-sponsors of this bill, including yourself, Madam Chair. This bill has been filed by myself with the help of the New Hampshire Chiefs of Police. It is proposing to make changes to New Hampshire's so-called bail reform law that came about as a result of Senate Bill 556. Madam Chair, and perhaps Senator Gannon and Senator Khan may well remember the debate about Senate Bill 556, where I think we were assured that the goal of making sure that people that have limited income have the same access to bail as people of more sufficient means have. And I think we were told that under Senate Bill 556 that violent criminals would not be released. I think we were assured also that there would not be a spate of repeat offenders if bail was easier to obtain. It obviously has not worked out that way. I think it's not necessarily fair to assess blame to any one individuals. I think Senate Bill 556, which I was a co-sponsor of, was well-intended, but it hasn't worked out. And I think it has undermined public safety in New Hampshire, as we have seen repeat instances of criminals that, alleged criminals that have been released from custody on bail, who have repeated violent crimes again and have not showed up for their judicial proceedings. And so Senate Bill 92 seeks to correct in a surgical way some of those problems. Number one, there are four pieces of the bill. The first piece of the bill, last year, and this is somewhat unrelated to bail, there was a law passed that reduced the penalty to a violation for criminal mischief vandalizing, defacing, destroying, tampering with public property. I was told after the fact that it was reduced in order to make prosecution more readily apparent, but police chiefs have told me that wasn't necessarily the case. So the first provision of Senate Bill 92 restores what had been a penalty for criminal mischief to a Class A misdemeanor. I think given what we've seen around the country, having that a more enhanced penalty for public defacement of property is appropriate. The second part of the bill are the bail provisions of the bill, starting on line 7 of the bill. It makes several corrections. It makes it very clear what criminal penalties we are talking about on the top of page 2. Homicide, first-degree assault, aggravated felonious sexual assault, kidnapping, trafficking, felonious use of firearms. And what that means is that there would be a rebuttable presumption the person charged is a danger to the public. This would allow potentially dangerous criminals to stay confined and not automatically get bail. Further along in the bill, starting on lines 24, talks about when people have not appeared for judicial proceedings on a number of different occasions and basically thumbing their nose at the judicial proceeding and repeatedly having gotten bail. I think you will hear testimony from various police officers today, Madam Chair, about what their departments have experienced as a result of Senate Bill 556 and why Senate Bill 92 is absolutely essential to protect the public. Madam Chair, I think you know that from your work, and I think Senator Whitley also, but also Senator Gannon and Senator French, but you were a leader in the effort, Madam Chair, to make corrections to the Division of Children, Youth, and Families to prevent child abuse and child neglect. Senator Whitley was one of the prime architects of Senate Bill 14 when she was an attorney outside of being a senator, and certainly is to be commended for that. And we have had a huge effort over the years to try and do a better job of protecting children from abuse and neglect. We have also done a lot of work going back to when I was first in the New Hampshire House many, many years ago, when we passed stalking law to protect spousal abuse and domestic violence. And so it is sort of contrary to that we have had the kind of problems that we've had with people being released on bail that should not be released. And I think that as you hear the testimony from some of the police officers and police chiefs that you're going to hear today, you will find this a compelling case for passing Senate Bill 92. I'm just going to touch on a couple of the cases that have been brought to my attention. Shooting in the city of Manchester on November 1st of 2020. The gunman was released on personal recognizance bail. He was also a convicted felon, and he was should have been held for multiple crimes that had been committed previously, but he was given PR bail. Another incident in Portsmouth, May of 2020, a suspect threw a bat through the window of a sandwich store downtown, waited for police to arrive, and then led them on a pursuit. The pursuit ended in the town of Newington when this individual intentionally rammed another car. He was arrested and promptly let out on bail. Subsequent to that following morning, apparently he paddled a canoe across the Piscataqua River from Kittery, docked in Portsmouth, went to the Portsmouth Middle School. At the school, smashed the front glass door and tossed a propane bottle in, and proceeded to light the bottle on fire, causing a small explosion in the lobby and a subsequent fire. This type of activity is certainly problematic when somebody is not held in those circumstances. A couple of other quick cases that involve domestic violence. In New London, people were arrested on domestic violent assault and given bail. I think as you hear the testimony from the police chiefs, this will become very apparent why we need this bill. The one thing I would ask the committee to consider, if you look on page 2 of the bill, I went through the list of potential criminal activities, felonies, most of them, that were cited in the bill. I think we should consider adding to the ones cited. It would be lines 1 through 7 on page 2 with the following. And if the committee agrees with me, I can have an amendment prepared that would also include felonious sexual assault. What's highlighted in the bill is aggravated felonious assault, domestic violence, stalking, child sexual abuse images, computer pornography, and child exploitation. I think these would tighten the legislation even further, and if you agree with me, I'd be happy to add that amendment. So I, with the strongest support for this bill, commend it to your review in the Judiciary Committee, and thank you very much, Madam Chair.
Thank you very much for your testimony, Senator Bradley. Senator French has a question.
Thank you, Madam Chair. Thank you, Senator. Great bill. I just have a couple of problems with it. I need some understanding. Page 1, changing from violation to Class A misdemeanor. If it says permanent or temporary on public property, if someone were to put up a sign in front of the State House without permission, would they be breaching this law?
I don't believe that's vandalizing, defacing, destroying, tampering with, or
It's
any,
unauthorized alteration, I would think.
no, Senator French, that question could probably be better answered by the Attorney General's office or a prosecutor, but all this change does is take it back from what had been a Class A misdemeanor that was categorized, I believe it was 2 years ago or maybe a year ago, to a violation, back to a Class A misdemeanor. So there's no other change of law in this section than the change in penalty.
Okay, one other question.
Yes, follow up.
Page 2, line 5. The person upon arrest shall be detained for a period of not more than 72 hours.
Mm-hmm.
That, so does that prevent them from being released earlier? And does it prevent them from being held longer?
So you would be better advised to ask that question of, the police chiefs that will testify after me. But my understanding is the language creates a rebuttable presumption, which currently is not in law, that that individual charged is a danger to the public for those crimes.
Okay, I'll ask later. Thank you.
Senator French, if I can. I'm looking at this and it says, the person upon arrest shall be detained for a period of not more than 72 hours. So that is the longest you can hold someone. If they want to release the person before that, they certainly can, but they cannot hold them longer than 72 hours. That's the longest they can do that.
So my question was, is that long enough for first degree assault, for sexual assault? Or does it limit us to only holding them for 72 hours with this presumption of rebuttable presumption?
I think what it does, Senator French, is ensure that there's adequate opportunity to get in front of a judge. But again, please ask the people more knowledgeable about this than I.
Okay. Thank you very much.
Next, we have Senator Whitley.
Thank you, Madam Chair, and thank you, Senator Bradley, for taking my question. So the way that I'm reading the bill, it does look like it really does reverse a lot of the provisions from SB 556. And I'm curious whether these changes were brought to the Bail Commission and whether the Bail Commission had reached consensus on these changes.
No, I worked with the New Hampshire Chiefs of Police on this piece of legislation, and I worked on it as a result of the multiple examples that I think we've all read about in the press, as well as my conversations with police chiefs, that the passage of Senate Bill 556 was a significant problem that undermined public safety in the state of New Hampshire. And while, to the best of my knowledge, there has not been a murder as a result of somebody getting bail, I think it's a matter of time before something as egregious as that happens. But there's certainly been crimes against people. There have been crimes against property. These are not victimless crimes that have been committed when people that should have not had access to bail got access to bail and repeatedly or became repeat offenders. And I think that's what this bill is trying to address.
Follow up.
Thank you. So again, because the bill just does undone a lot of work, I mean, I do think that it would make sense to hear from the Bail Commission and, you know, have them have an opportunity to provide some input. So as a follow-up to, you know, some of the anecdotal stories that you have shared about some terrible incidents, I'm wondering if the chiefs brought to you some data spelling out what has actually happened as a result of SB 556, in addition to anecdotal stories. I would think that we would want actual data in front of us when we're going to undo a lot of work that has been done.
Well, when does anecdote become data? I think the example I used of somebody trying to create an explosion in the Portsmouth Middle School is enough of an anecdote to say we have a problem here. I think the examples, and you will hear from them, from the police chiefs, of domestic assault, violence, you know, against spouse or children, is a serious danger to the community. Again, as I said in response to your first question, these are not victimless crimes. These are crimes with victims and often perpetration of violence. And I think we have to deal with that. I think looking at it in terms of just analytical data misses the point that real people are being hurt by repeat offenders and offenders that in particular in domestic situations are going right back to the victim and re-abusing, and that's what this bill tries to prevent. And I think, Senator, you know, given the excellent work that you did to help draft Senate Bill 14, that you would be very, very concerned with that kind of abuse, and especially when it targets children.
Just certainly, I think we need to look at both the anecdotal stories, what has happened, the result of the changes, coupled with data, and then get some fixes that involve all parties. I mean, it does feel like a sort of one-sided approach to fixing something that has been years in the making. Feels one-sided. Thank you.
Okay.
Thank you. Are there any further questions? Senator Khan? Senator Khan, you need to come off of mute. There you go.
Thank you, Madam Chair. Thank you, Senator. You've been generous with your answers to questions, but if I can just ask you about page 2 and line 24 through 29. I just wonder if I'm reading that correctly. That anybody who has previously not appeared for any of the crimes listed on line 25 or 6, if they should commit another crime, that they will be detained. Is that the way that I should read that?
So I think the police chief from Bedford is going to testify on that specific section of the bill and how it fits together with C, starting on page 3. They're different criteria. I think he could far better than I explain, as it was tried to be explained to me earlier this morning. What you will hear from police chiefs is that without the threat of being held in jail, people are just not showing up at judicial proceedings time and time again. And this is a measure to try and ensure that people are detained in pretrial detention when they should be, as opposed to being let out on bail and then being no-shows in the future.
I'll look forward to hearing more on that section. Thank you, Senator. Thank you, Madam Chair.
Are there any further questions from the committee? Okay, seeing none, thank you very much, Senator, for your testimony this afternoon.
Thank you, Madam Chair.
Okay, next I'm going to, I'm looking here because Senator, I see Senator Ricciardi would like to speak.
Good afternoon.
Good afternoon, Senator.
Good afternoon, Madam Chair and committee members. For the record, I'm Denise Ricciardi and I represent District 9. I am proud to be a co-sponsor of this bill. I wanted to tell you that as vice chair in my town, I read the police reports every month, and this is a problem that does need to be. It's really simple. Safety of everyone in New Hampshire. Violent and non-violent criminals have been put back on the streets and neighborhoods of New Hampshire, and time after time reoffend and victimize others. This revolving door of crime that emboldens criminals to keep doing what they've been doing has to stop. At what point, how many chances do we give people before we say enough? How many more victims do we allow the same offender before we say enough? I have heard from my chiefs and other chiefs about the violent criminals being put back on the street before the officer actually finish the report. The crimes in this bill are violent crimes, and the offenders in this bill have been given many chances to change their behavior, but they don't. They continue to abuse the chances they have been given because they know they can get away with it. It's time to think about our victims. This bill needs to pass for victims of crimes. Thank you.
Thank you very much for your testimony, Senator. Are there any questions for Senator Ricciardi? Okay, seeing none. Thank you very much, Senator. Okay, and next we're going to go to John Barfonsky.
So I do not see your name. If you could virtually raise your hand, or if you were on a phone, you can dial *9, but it looks like.
Yes, good afternoon, Madam Chair and members of the committee. My name is John Berfonsky, and I am the chief in Bedford. I've been the chief here almost 10 years, and I've got going on 43 years of continuous law enforcement experience, and I'm representing the New Hampshire Chiefs of Police today in soundly and roundly supporting the provisions of SB 92 with respect to the changes concerning the release of defendants or people charged with crime. As we've already heard, members of the committee, this bill is about the safety of you and your families and everyone in the state of New Hampshire and everyone who lives, commutes, or visits and vacations in our great state. And as you've heard, it is about the victims of crime, most importantly, about the victims of crime. And with all due respect, we don't believe, this Chiefs Association does not believe it undoes much of the previous bail reform, but only addresses some surgical changes, as Senator Bradley has indicated, that needs to correct some deficiencies that have been identified as a result of the previous reform. But most importantly, and I want to bring this up now, it is not about money, and it's not about the inability or ability to pay for bail. It's about victims of crime and about people who reoffend crime. It corrects the deficiencies in the current law that permits persons arrested and released on bail to reoffend over and over and over and over again. Most importantly, recognizing that it leaves behind a wake of new victims each time. The chiefs are concerned, members of the committee, that if we've reached a point here in New Hampshire criminal justice that it basically takes a completed homicide to hold someone in pretrial detention. It's important to note that the bill does not eliminate bail, but it only requires a person who is alleged to have committed a violent crime, again, violent crime, guns, homicide, first and second degree assault, sexual assault, and so forth, to be held until a judge can properly consider whether or not the person charged could be safely released. So there is still the provision for bail. It only holds those people who have been arrested for committing a violent crime to be held until that person can appear before a judge in the Superior Court. The other provisions of the bill requires a person who violates the terms and conditions of release by reoffending not once, not twice, but at least 3 times or more to be held until trial. Now, I'm going to just give you some information. These are not stories. These are real cases. You've already heard from Senator Bradley with respect to a case in Manchester, an egregious case involving a shooting, and another case in Portsmouth. So in Portsmouth, there was another case involving a subject who was arrested for felony receiving and breach of bail. The subject was released on personal recognizance, rearrested for felony receiving stolen property and breach of bail again and released, and arrested and released again for the same charges for receiving stolen property. And this same person had a similar record in Concord. In Newport, New Hampshire, there was a case involving drug dealers that had chased down and shot 2 people in Newport, and that person was released on PR bail. In Keene, there was a case involving a felon who stabbed another person, and that subject was arrested and released on PR bail. In Franklin, there were cases, several cases the most egregious of which a subject was arrested 10 times, including domestic violence and stalking, and released on PR bail. Another subject was arrested on 7 counts of breach of bail and 2 counts of domestic violence and criminal threatening, and released on personal recognizance. And another case in which a subject was arrested for felon in possession of a firearm, was already out on a 4-year prison sentence release, reoffended and was arrested and released. In Lebanon, a subject pointed a weapon, a gun, a handgun, at the head of a female woman, and the subject was released on personal recognizance. In Haverhill, a subject was arrested for domestic violence, including discharging a firearm inside the house with the children in the house, assaulted the spouse, and the subject was released on personal recognizance. Another case in Haverhill in which the subject was arrested 7 times for felony offenses and released each time on personal recognizance. In Concord, similar cases, subject arrested 3 times for breach of bail, stalking, released on personal recognizance each time. Another subject in Concord arrested and released 4 times, personal recognizance, breach of bail. Another subject 5 times arrested and released on PR bail, including assaults. There was an arrest of the subject on arson and stalking, and the next day the subject stabbed a mass trooper. So let me repeat that one again. A subject was arrested in Concord for arson and stalking, was released on PR bail, and the next day nearly fatally stabbed a Massachusetts state trooper. In Bedford, cases that Senator Ricciardi spoke of, a subject that we have arrested more than 10 times, not including arrests in Wakefield, Massachusetts, and elsewhere, including 2 completed burglaries. Each time the subject was arrested and released on PR bail to reoffend, again, including 2 commercial burglaries here in the town of Bedford. Another case in Bedford in which 2 subjects who had been released on PR bail for previous crimes, including one who was wearing an ankle bracelet, was arrested for committing a commercial burglary in Bedford, released, and then committed a second commercial burglary in Bedford and was released. So these are only a smattering of members of the committee of a number of cases that the chiefs had. But again, this is absolutely not about depriving persons of their freedom because they can't afford bail. It's not about the ability to pay. It's about making sure that persons who have already committed crimes and continue to violate their contract with society by reoffending over and over again are held accountable until their cases can be adjudicated. There are cases upon cases upon cases in which offenders reoffend several times, in fact, dozens of times, and are released only to reoffend. But it's more important to think about, as I do, and as all the chiefs do, about the victims of property crime. One gentleman here in Bedford who had all his power, he's a tradesperson, he had all his power tools stolen by a subject who was arrested and released on PR bail a number of times. We've got to be thinking about what the impact is on the victims of crime, people like this tradesperson whose entire life savings is impacted by people who continue to commit crime after they've been released. So the New Hampshire criminal justice system essentially in some cases has become the New Hampshire criminal inconvenience system because all it does to repeat offenders is inconvenience them. Meanwhile, victims struggle to pick up the pieces. So we urge you and implore you to pass this bill. Thank you, and I'll take questions.
Thank you very much for your testimony this afternoon. Senator Whitley has a question.
Thank you, Madam Chair, and thank you for taking my question. Chief, you may know that I spent my entire career devoted to building up the system of supports for vulnerable communities, individuals with mental illness, children, vulnerable families. My entire career has been devoted to supporting those folks. So I am not immune to hearing difficult stories and working together to develop solutions so that doesn't happen again. I'm also the mother of a young child. And so, having a safe community means something to me and to my family. I do, as I said before to Senator Bradley, I do think when we are looking to undo major reforms, that we both need to couple the stories that you are sharing with data. So I'm hoping you can share with us any data you might have about the percentage of people released pre-trial who then reoffend. Are you able to share with us that data?
Well, Senator, you're asking for a data call that frankly doesn't exist. There are no statewide records management systems here. The state criminal justice system, the reporting system is ill-equipped to provide that information. Can it be done? Yes, it would require a hand search of records from the state police, from every county police department, sheriff's department, and every police department in the state. What we've been able to accumulate to this point are the cases that are the most egregious that come to the minds of the chiefs that were asked to provide the information. Can you provide the additional information? Certainly. It would require an extensive period of work to be able to do that.
Great. Do you have a follow-up, Senator, or are you all set?
I mean, that kind of data would be important for me to see to undo provisions of reform that has happened in the past that, sort of hasn't gone before the bail commission. I mean, right now it does feel like a one-sided reform. And so I would like to see that additional data.
Okay. All right. Are there others? Senator Khan.
Thank you, Madam Chair. Chief, thanks for your testimony. I'd like to ask the question to the bill that I asked of Senator Bradley. Could you look at page 2 and line 24 through 28 and just help explain that so that I have an understanding from you? That'd be helpful. Thank you.
Certainly. First, let me say that I'm ill-equipped to go by line because the copy of the bill that I have in front of me doesn't have it line by line. But if you're referring to on page 2, that would be section 3, B2, where it starts, if the court determines by a preponderance of evidence that a person has failed to appear. Is that the section you're referring to, Senator?
Yes, it is.
Okay. So this particular section addresses failure to appear. And that is in relation to a number of these cases in which people that have been released on personal recognizance and frankly, other bail, failed to appear when committed breach of bail and failed to appear. And we continue to rearrest them. Many cases in Bedford that I'm aware of here in my own department, where our officers arrest someone for failing to appear, breach of bail. We bring them into the station, about 40 minutes to process them and release them on PR bail again. And this is not the first time that particular subject was arrested and released on PR bail for failing to appear. It frankly consumes law enforcement resources that no police department, including the state police, have available to them to continue to pursue a revolving door escapade of bringing people in, processing them, filing another charge and releasing them, and then they don't appear again. The other section that I think that you were referring to is on the next page, at least for me anyway, section C, and that pertains to failure of a person to abide by previous bail conditions. So in the first case, we're talking about failing to appear. In the second case, we're talking about a person who fails to abide by their conditions. And that could be, for example, the judge may enter a condition that indicates the subject arrested should not consume alcohol or should not consume drugs. So that's a bail condition, or stay away from a protected party, for example, or not possess firearms. And then they then are found in possession of firearms, or they are arrested after consuming alcohol. So one is failing to appear, and the second piece pertains to conditions. I hope that helps you understand that.
It does. I presume that in particular on page 2, or the previous section that we talked about on detention, failure to appear, that suddenly the universe of the number of people before the courts with pending charges expands exponentially. Would that be your perception as well?
No, I don't think that that's the case. I think that the laws that members of the legislature enact serve a couple of purposes. One, and most importantly, they send a message to the public. And in this case, they will send a message to the public that if you fail to appear, you're going to be held in detention until your court case comes up before a judge. That should serve to induce folks to not fail to appear, because they know if they do fail to appear, they're going to be held. So I don't believe that it would result in an exponential increase. In fact, I think that it would induce most people, rational people, and we're assuming that most of these people are rational people, will understand the law. They will be told by their defense attorneys that, listen, don't reoffend and make sure that you show up, because if you don't show up for court, you're going to get arrested and you're going to go to jail, and there's nothing that I can do to help you. And that should serve to induce folks to follow the law. So I don't believe that it would result in an exponential increase.
And it does say.
Follow up?
Thank you. And it does say at any time in the 5-year period, right?
That's the look back period, Senator, that indicates that the person has failed to appear.
Thank you.
Senator French.
Thank you, Madam Chair. And thank you, Chief, for coming today. Just to follow up on Senator Khan's question, I too have concern about that paragraph. And it says failed to appear on any previous matter. That would be any other case, correct?
That's correct, Senator.
And that looks back 5 years. So a Class B misdemeanor does not carry jail time. Is that right?
That's correct.
So what this law would do, if I was charged with a Class B misdemeanor 5 years ago and failed to show up for one of my dates, but then finally went to court and was found not guilty, and then I was charged with another Class B misdemeanor 4.5 years later, I would be held in detention until trial?
That certainly should serve, Senator, to induce folks to show up for Class B misdemeanors.
Got you. That's what I thought. Thank you very much.
Okay.
Thank you, Senator.
Are there any further questions from the committee? Senator Whitley.
Oh, sorry about that. Thank you, Madam Chair. Thank you for taking another question, Chief. I'm wondering whether you would be willing to go to members of the Bail Commission to reach consensus on language of this bill.
Well, I think that would be up to Senator Bradley and the co-sponsors of the bill to determine how best to proceed forward with this. I do believe that in many cases that the chiefs around the state, and I'm a member of the executive board of the Chiefs Association, so I do get to see many, many chiefs from all across the state, not just in southern New Hampshire. There is resounding concern that there is a very wide disparity in how bail commissioners, even within the same court district, apply the language in the current law. And so the chiefs believe that the best way to address Again, this is not total reform. This is looking at violent crime and multiple reoffenders, is to be more explicit and specific in the law that directs people to be held under certain conditions, or at least until a judge can properly review the case to determine whether someone charged with a violent crime should be released. So that's my answer. I would think that this bill is more than adequate and stands on its own.
Okay, are there any further questions? Chief, I have a question, and it's maybe I'll get to the question. I was a member of Senate Judiciary as well as chair of Senate Judiciary when Senate Bill 566 was presented to the committee. And one thing that was said over and over and over to us again was that this was not going to apply to violent offenses. And I think that that's one reason why this bill is here today, is the fact that it has been applied to people who commit violent offenses. Now, I'm not sure, I don't remember if you were there at the public hearing, but the issue of data has been brought up. And I can say that I've reviewed my file from that bill a few years ago, and there was no data presented to the committee whatsoever by any entity on any problems that we had here in New Hampshire. It was based on the fact that we did not want to see people held who hadn't committed a violent crime, who had committed maybe a minor offense. We didn't want to see them held for unreasonably and denied bail. And so I just find the conversation about producing data interesting. Do you have that same recognition? Because I believe you've been following this issue for quite a while.
Thank you, Senator. Yes, my recollection is that there was no specific data that was presented in the initial bail reform legislation or leading up to it that gave anyone a predictor of how this particular reform, the initial reform, would affect criminal justice. But I can say resoundingly, again, on behalf of the Chiefs Association, that no chief of police in New Hampshire, no law enforcement officer wants anyone to be held unreasonably. No one wants people to be held simply because they can't pay. And that's why this particular bill, with these very closely applied surgical changes with respect to violent crime and exponential repeat offenders, addresses those two particular concerns.
I'm going to follow up with a would you believe question. I've spent some time talking with police officers, chiefs of police about bail reform. And one of the things that I've been told is that a lot of people know now that if you just say, hey, I don't have any money, I can't afford this, they have to let them go. And so would you believe that that is something that is happening across our state?
I certainly believe that, Senator, and I know that it's occurred here. We talk to folks that we've arrested, and they tell us what motivates them to do what they do on some occasions. But I think that the problem has devolved to the point where even that is no longer necessary, because most people are being released on personal recognizance for the most egregious cases. When someone who is from Massachusetts and is a convicted felon possessing a firearm that's already a violation of both federal and state law comes to the city of Manchester and shoots up the streets in the city of Manchester on a weekend, shoots someone, thankfully doesn't commit a homicide, is arrested and then released on PR bail, there's no need to say that they don't have any money. I don't know how it gets any worse than that.
Okay, thank you very much for your testimony this afternoon.
Thank you.
The chair will call Michael Carnigan.
Hi, good afternoon, Madam Chair and committee members. Thank you very much for the opportunity to let me speak. Can you hear me okay?
Yes, we can.
Thank you. My name is Michael Carrigan. I'm the Chief of Police in Nashua, New Hampshire. I've been in law enforcement for almost 28 years. I was born and raised in Nashua, and I'm proud to serve the community that I represent. I'm here today to testify in support of SB 92 on behalf of the department and also the New Hampshire Association of Chiefs of Police. I'd like to speak to you a little bit specifically about the bail reform portion of this bill and maybe answer a couple of the questions that you may have regarding some of the comments that you've already made. The proposed changes that we're talking about that Senator Bradley has sponsored, there are critical steps towards striking the balance between protecting the citizens from danger and still maintaining the presumption of innocence for an accused offender. The changes here, the surgical changes that Chief Vronsky spoke about, allows the officers to express their observation and experience to be considered when we think a person is a danger or a risk to an individual in the public. It allows common sense to be factored into the equation. And I'm sure you've seen examples and heard some of the horror stories as you've been listening to today on people that have been released immediately. These changes allow us to articulate in front of a judge why we feel there's a danger to the public. We need to be able to do this. If we can't, these people are getting let out right away. We owe it both to the citizens to give them comfort and peace, knowing that we're there going to keep them safe. I'd like to really quickly thank Senator Bradley for mentioning an amendment to add domestic violence to this bill. I think it's critical, and the example you're going to hear from me right now, and I'll keep it brief, will express that. And I think it demonstrates probably a worst case scenario to me than Chief Vronsky just spoke to. Back in December of 2020, we received a call for domestic assault in progress. The subject had arrived at the house, he'd brought a firearm to the house, and he had forced his way in and was threatening to assault a female. We arrived, were able to place him under arrest and bring him to the National Police Department. We conducted what we call a lethality assessment program, where we asked the victim several questions to see how high of a risk they are. That victim on that occasion screening yes to every single question, putting her at the highest risk possible to be in danger of possibly being killed. We went to the station, he was booked. We expressed 3 different times to the bail commissioner, and I'd like to speak, hopefully answer Senator Wheatley's question after with that. We responded 3 times to the bail commissioner, expressed to him, A, his violent history, B, the fact that he had brought a firearm, and C, the fact that she screened in on every single question. All 3 times, the bail commissioner says, no, that doesn't change anything. He was released on $200 bail, and when he got out, he immediately returned to the victim's house, broke in, proceeded to beat her and rape her for the remainder of the night. This is a female citizen in Nashua. She deserves the protection of us as a police department and us with the bail commissioners to be able to keep that suspect in jail, at least until we can present to a judge that why we felt he needed to be kept in. Senator Wheatley had mentioned about the bail commissioners and their perspective and their data. Unfortunately, I don't see her on any longer, but I just want to, I guess, to speak to her point, conversations we've had with the bail commissioners, the frustration is, Senator Wheatley, thank you. I respect your concerns about the bail commission in their perspective. And I don't have an answer as to far as articulating the number. Like Chief Vronsky said, the data record management systems just don't allow us to capture that. But a lot of the frustration for us and for them is that they can't seem to listen to the experience we have and the reasoning behind why we feel this person should be in jail. They almost feel like their hands are tied with the rules. And again, it's an inconsistent determination by different bail commissioners, but it's frustrating nonetheless because of our experience and I've got 27 years in law enforcement. If I think someone's a danger and can articulate why, I would hope it would be listened to for a period of time. No different than presenting a judge with a warrant or a testimony to have somebody arrested. That's our credibility. So I think I appreciate your time. I'd be happy to answer any questions. I think it's critical that you add domestic violence in there because it is such an impactful crime for victims. And as I said, a young lady was beaten and raped because multiple times because we let her out on $200, the suspect out on $200 cash bail. But I really appreciate your time. I appreciate you taking this on. And Senator Wheatley, I'd be happy to work with you to try to figure out the answers to your questions to continue to support this bill.
Thank you very much for your testimony. Are there any questions from the committee? Okay, seeing none, thank you very much. The chair will call Robin Malone.
Good afternoon, Senator Carson. Thank you for the opportunity to speak. Good afternoon, committee members. I appear this afternoon as a representative of the New Hampshire Association of Criminal Defense Lawyers. I've been an attorney here in New Hampshire since 2004. I've represented thousands of defendants charged with everything from motor vehicle violations to homicide. And I also have a robust practice representing victims of crime at both domestic violence hearings and as they navigate the criminal process. NHACDL opposes both the proposed bail amendments and the criminal mischief amendment included in this statute. I've submitted written testimony, but I want to highlight a couple of our specific concerns. I'll speak first to the criminal mischief statute. This amendment, candidly, is unnecessary. It does nothing to increase options for prosecutors. I've spoken to many at both the Superior Court and the Circuit Court level, and they agree that it does nothing to help resolve matters in court. Like many criminal statutes, the criminal mischief statute covers a wide range of conduct. And in my practice, I've seen the full spectrum. I have seen this statute used to charge teens who have used sidewalk chalk to scribble on a door. I've seen it used to charge college students who have sprayed whipped cream and chocolate sauce on a car. And in those cases, there was no monetary damage. The defendants were ordered to write letters of apology and to do community service hours. But with this amendment, that conduct would have been a Class A misdemeanor, which carries a risk of jail time. It triggers disclosure requirements on employment applications, saying that the applicant has been convicted of a crime. And I would respectfully suggest that such severe punishment for that conduct was unwarranted, inappropriate, and a waste of resources. Others of my criminal mischief clients have faced the charge for actually damaging property. And I think we can agree that damaging property is a step above sidewalk chalk and whipped cream and chocolate syrup. I think we can also agree that when felonies are charged for causing significant property damage, that those individuals are appropriately charged with a felony. And again, I hope that we can agree that the range of crime from whipped cream to major damage and property damage is significant, and that they warrant different levels of punishment. This amendment does nothing to add to a prosecutor's tool belt, but it takes much away. Our laws are drafted to correlate the level of punishment with the quality and quantity of the offense. A Class B misdemeanor has a place here, and writing it out takes away a solid negotiation tool for prosecutors who frankly regularly use this Class B misdemeanor to educate young people and divert them from further conduct. I want to speak next to the proposed bail amendments, which are very concerning for us and for many in the criminal justice community. I have a great deal of respect for the chief from Bedford, and he indicated in his statements that he was offering examples of the worst because there is no data. But respectfully, legislative changes this expansive should not be made based on the actions of the worst of the worst. These are too sweeping. In the past 4 years, bail reform has been in the forefront here in New Hampshire as we catch up with the rest of the country and how we treat those charged with crimes. There were bipartisan efforts to create the commission in 2018 that has been spoken about here. And while the statement that things have not worked out, I'm not clear where that is coming from. Nothing included in SB 92 is at all representative of what was in the report from the commission, issued as recently as November of 2020. And with the additions proposed just this afternoon, a significant portion of those accused of crimes would be presumptively detained. Bail cannot be punitive. The constitutional presumption of innocence requires that we do not automatically detain those accused of committing crimes. Yet these proposals would create a presumption of detention that would likely significantly increase the number of defendants detained pre-trial. Any prosecutor will tell you that the seriousness of an offense is not determined by the RSA under which the defendant is charged. This presumption of detention would also increase the court docket, forcing courts to schedule hearings for any defendant charged with any of the named defenses and presumptively detained. Right now, by way of example, the morning list in larger courts, such as Hillsborough County Superior North, can run well into the afternoon. The morning list. The prosecutors have the ability under our current statute to ask that any defendant can be detained, even if they have been released by a bail commissioner. The proposal on the additions proposed this morning would guarantee that this list grows longer and takes significantly more of the court's time. As was the topic of significant testimony for the bail, even 24 hours of detention can be life-altering for defendants. Indigent defendants specifically would be impacted by these changes. A career is not the same as having a job. Missing one day of work can lead to a loss of job. Loss of job can lead to loss of employment. That could lead to housing instability and food insecurity for the defendant and their family. And frankly, finding a new job while criminal charges are pending is incredibly difficult. So even if a defendant is eventually able to overcome that presumption and secure release, the damage may well be done. Those same concerns are relevant as they as they relate to the FTA amendments. Both proposals ignore the significant distinction between flight and failure to appear. The former is rare and a deliberate effort to flee the jurisdiction and could appropriately and would appropriately be considered when assessing bail for a defendant. The latter, a failure to appear, occurs regularly and often unintentionally for both defendants and witnesses in cases. Court notices were sent late, changes of address, dates misentered in calendars, dates misunderstood as having been continued by motion or simply forgotten. That is not a reason to detain somebody. While it is an inconvenience for sure, those events do not warrant a presumption that an individual should be detained pre-trial, which places their employment, their housing, and their lives at risk. The second proposed amendment calls for a presumption of detention when a defendant had on a prior occasion violated bail conditions by committing a new offense. This proposal overlooks the reality that many of those reoffenses are not violent, but rather related to substance misuse disorders and mental illness. This proposal would lock them in jail. Judges are in the best position to assess the facts and details in each case and make a fact-based finding for release. While these proposals may be intended to capture those seeking to thwart the courts, enacting this change would ensnare and harm many more and would serve to make our communities less, not more stable. Finally, these measures are further inconsistent with efforts here in New Hampshire and across the country to decrease jail populations during the pandemic. While New Hampshire has been fortunate to see only 2 inmate deaths result from COVID, the number of outbreaks, the frequency of outbreaks, the number of infections and hospitalizations are undeniable, and their extent, frankly, remains unclear. The state's largest jail ignored CDC guidance for facility management for more than 9 months, failing to even require mask use or screen employees entering the building. The result was an inmate COVID infection rate of 50%, brought only to the surface by the diligent work of attorneys and the press finally picking up the story. Further, because of the inability to advance criminal cases, our courts are facing an unprecedented backlog of criminal matters. This has already resulted in longer than usual pretrial detention for inmates awaiting trial. Some are well past 8 months, 9 months, 16 months, 18 months awaiting trial. Some of those cases will go away. Some of those defendants will be found not guilty, but their lives have forever been impacted by their pretrial detention. Those of us working with the courts to find ways to resume a robust criminal docket recognize that it will take years to dig out of this backlog. Now is not the time to add a presumption that will lead to an increase of incarcerations in dangerous congregate settings for defendants, nor to add to the docket. Add presumption, Adding a presumption will add hearings. Most defendants are safely released pending trial and will not ultimately be sentenced to serve prison or jail sentences. These proposals are far too sweeping. We appreciate the examples offered in the presentation for this bill, but these proposals would ensnare far more than the targeted activity. The vast majority of those arrested and released on bond do not commit new offenses while on bond, and they appear as directed. The vast majority. The exceptions should not make the rule, and that is what these proposals do. Thank you for your time.
Thank you for your testimony, Ms. Malone. Are there any questions from the committee? Senator Gannon.
2 questions. In the part 1, and you are way more well-versed in this area than I am, so I'll try, so be gentle. Criminal mischief. What if we took out tempered, we took out temporary, and authorized alters, we made it a little tighter? Would that be acceptable to you?
I'm sorry,
You had your whipped
I'm
cream
looking at the right
variants.
section.
Criminal mischief, section 1.
Criminal mischief, section 1.
Tempered, temporary, unauthorized. You were talking about whipped cream at the beginning. Things
Yes.
are shot. I understand where you're going with that. So if we made it a little tighter and just left in the harder stuff, vandalized, defaced, took out the lighter things like that wouldn't include shock, a temporary thing, would that please you at all in that section?
I think it would temper my concerns. I think candidly, the conversations that I've had, and anytime I testify, I do speak to both sides, the prosecutors and the defense attorneys. The Class B misdemeanor is a valuable tool that is used regularly for prosecutors to take, frankly, stupid conduct. There is a vast distinction between pranks and even pranks that cause minimal damage and the upper end of criminal mischief, which can involve baseball bats, damaging windshields, and such like that. I would encourage the committee to leave the Class B misdemeanor as an option. Frankly, regularly, we will also see prosecutors bring in a Class B misdemeanor and reduce it. I'm sorry, a Class A misdemeanor, but ultimately reduce it to a Class B. That has value because it forces the individual to go through the process with the threat of a Class A misdemeanor, recognizing the possibility of a more serious penalty, but in the end, benefiting from the Class B misdemeanor. It gives the prosecutor an opportunity to recognize work that individual has done, whether it be, coming in with community service or a letter of apology. And frankly, I think that sometimes youth leads to really bad decisions. And I don't think that those decisions should follow youth the same way that perhaps it should follow somebody who commits what I would view as Class A misdemeanor level vandalism.
Thank you.
Thank you very much for your question.
Are there any further questions? Okay, seeing none. Thank you very much for your testimony, Ms. Malone.
Thank you.
Okay, next we are going to have Jean Harusk.
Good afternoon. Thank you, Madam Chairwoman and members of the committee. My name is Jeannie Haruska. I'm the political director for the American Civil Liberties Union of New Hampshire, and I really appreciate the opportunity to testify today in opposition to SB 92. I'm deeply disappointed, to be frank, to see legislation related to bail reform be introduced that does not reflect the work of the Bail Commission. As this committee knows, the legislature created a multi-stakeholder bail commission in 2018, which included judges, county attorneys, law enforcement, legislators, public defenders, and the ACLU. Last year, a bail commissioner was also added to the commission. The Bail Commission met regularly for 2 years, recommending the reforms that were subsequently passed in 2019 and 2020. The commission continued to meet in the off session last year and submitted a final report as recently as last November with several recommendations. However, this legislation reflects none of those recommendations. It does not include input from several stakeholders from the commission. As previous witnesses noted, This bill is coming specifically from the chiefs of police and just does not reflect input from the many other stakeholders that were on the bail commission. In fact, the spirit of this bill actually contradicts a finding from the bail commission's last report, which specifically highlighted that failures to appear have gone down during the pandemic, in part due to the expansion of telephonic check-ins. And yet this bill imposes significantly harsher penalties for even a single failure to appear without any consideration of whether that failure to appear was voluntary or involuntary. It doesn't take into account whether somebody was hospitalized, whether somebody was unable to take time off of work, whether they were unable to find transportation to the courthouse. There's no consideration for the reason for that previous failure to appear. And it also includes people charged with Class B misdemeanors, which, as previously noted, cannot result in jail time even if someone is convicted. It just doesn't make sense to detain someone pre-trial who cannot be detained if convicted. This legislation would also impose significant changes to a statute that was modified just last summer. Since the enactment of those most recent reforms, our state has been consumed by a pandemic, resulting in a host of unprecedented conditions and circumstances that are anything but normal. Given the pandemic, it is particularly difficult to draw conclusions about how the recent reforms to the bail statute will operate over the long term based on how they have operated over the past 7 months. We are concerned about rushing to change a system that was changed less than a year ago, when the state has had a chance to determine how those previous changes will operate. If we are given more time, if we're allowed to get beyond the pandemic, we'll have a chance to see how those most recent reforms honestly will operate. But no conclusions can be drawn at this point. Moreover, our jails and prisons are experiencing COVID-19 outbreaks, as the previous witness noted. This bill would likely result in more people being detained in congregate settings, putting people at heightened risk of contracting COVID-19 and imposing greater financial costs on taxpayers. And we share the concerns previously noted about increasing the penalty for criminal mischief. And I really appreciate, Senator Gannon, your question and your proposed change. And I agree the change that you suggested would certainly temper our concern. Our overall concern is that we're just not convinced that increasing the penalty actually increases deterrence. The research just does not bear that out. And so we're not convinced that increasing the penalty in this case will actually alter behavior. And it is for these reasons that I respectfully urge the members of this committee to vote inexpedient to legislate on SB 92, and I would be happy to take questions.
Thank you very much for your testimony this afternoon. Are there any questions from the committee? Senator Khan.
Thank you, Madam Chair. Thank you, Ms. Ruska, for taking this question. You used the observation that during the COVID pandemic, that the use of telepresence at court hearings has decreased the number of no-shows. Is that evidence and data that could be shared with the committee?
I appreciate that question. That was heard by the Bail Commission last year. The Bail Commission met monthly throughout the off session last year. And the courts were the judges on the commission were actually the ones who testified about the FTA rate going down. And there are certainly minutes from those Bail Commission meetings that I'm happy to provide the commission. And I'll just note that one of the recommendations from the Bail Commission was to actually continue telephonic check-ins after the pandemic because of the benefit that they have shown to reduce FTAs. It's just so much easier for somebody to take 5 minutes out of their day, make a phone call, than it is to have to take the whole day off of work, find transportation, and go to the courthouse in person.
May I follow?
Yes, follow up, please.
Are you aware of any legislation that is enabling telepresence at hearings that is up before the legislature this session?
I am not. I will say the courts took it upon themselves to allow for telephonic check-ins. That's something that the courts adapted to without legislation in response to the pandemic last year. And we have had conversations with the courts, and it sounds like they intend to continue them. So that's an issue for the courts to determine on their own, and they don't think it would require legislation at this point.
Thank you.
Okay, are there any further questions? Okay, seeing none, thank you very much for your testimony.
Thank you.
Okay, the next person I have is Andrew Shaguri.
Thank you. I hope you can hear me now.
Yeah, we can hear you.
So I'm here primarily on two sections, one the criminal mischief and the other on the enforcement investigations, about background investigations, which hasn't come up at all. But back to the criminal mischief. So to kind of put this in perspective, this law was not changed until January 1st of this year. So I was a little surprised to hear Attorney Malone talk about how it's impacted and it could be changed. It didn't take effect until January 1st, 2021. So I don't know how she had any cases under that. And secondly, this is really just going back to the original language that it was. As this bill was proposed last year, I believe it was in the House. And because the House had to stop their hearings, it got thrown into one of the quote unquote Christmas tree bills, if you will. But the House, before it went for a vote, the committee there made an amendment to change misdemeanor to violation for only for public property. And that's the kind of odd thing about this. I don't see where damaging public property should be any lesser than private property. And I say that because think about today, if somebody went and flattened a tire on a few tires on some DOT trucks, that could have a huge impact on public being able to make it down the roads, public safety. Somebody flattens a tire on a car, the personal car, that's a huge impact to a victim, but it's not so much an impact on society as a whole. So I think that's the important part. It talks, this is this amendment changed it to make it so it was a lesser penalty for damaging public property versus private property. Keeping it a Class A misdemeanor, though, allows that kind of flexibility that Attorney Malone talked about. We don't have to charge something as a Class A misdemeanor. We can always go down if it's a lesser offense. But if it's a violation, we can never bring it up if they were to do an extensive amount of damage. And I think you need to understand the other side of that. You can't go up. You can only come down as a prosecutor. The other part I was primarily going to talk about was background investigations. No questions to come up about that. No discussion. Largely that's because I hope it's not controversial. It supports the Lee Act recommendation number 14, which talks about background investigations about police officers. By background, I've been in law enforcement now for almost 33 years, 32 years full-time, 22 years as a chief of police. As a chief of police, and even prior to that, I was a district court prosecutor from both this department and my prior department. And I also was responsible for background investigations. And a few times you run into this concern of being sued. Employers worry that they're going to get sued if they release negative information about somebody. And that's really important for me from a background investigation standpoint, being able to get the full picture of who's applying to our agencies. If something's being not being released, and it really has to do with privacy and liability issues as to why they don't. It's not that they don't want to share it. This bill, that section does give confidentiality of that information that's released. And it also gives liability protection. I would like to address the bail part real quick because I was the president of the chiefs of police when this SB 556 came about, and I respect Senator Whitley's comments about having a total package of everybody involved in this. When SB 556 was put forward, we and county attorneys were specifically excluded from the original writing of that bill and how it was put forward. We didn't get to say anything later until it was getting ready to go to committee of conference. Partly that I'll take it on me. It was my fault because I was assured by our representative, a representative from the chiefs that was dealing with bail, that this has nothing to do with, you know, the proposal of 3 days count, nothing to do with violent criminals getting released. Well, unfortunately, we've seen that since. And quite frankly, my recollection is the same as Senator Carson's. It was anecdotal stories that were used to support the changes back then. And after 556 passed, I served on a couple of committees, and I served on the Interbranch Criminal and Juvenile Justice Council, and we discussed some of these issues. Unfortunately, when you have one police officer and you've got the public defenders, ACLU, the criminal defense lawyers having 3 seats, your one vote doesn't always carry the day in some of these bail commissions and study commissions. It's just the way it works. I get it. But to say it wasn't presented, I know Chief Toussaint from Rochester has presented many of these issues because he's faced them. One other point about Attorney Malone's discussions, the shooting in Manchester was November 1st. So she said, it's let these things take effect. Well, and it hasn't, and she was talking about after it went into effect, these changes, or maybe that was ACLU, Jeannie Hariska, but they were talking about, well, that shooting in Manchester with the felon from Massachusetts, that was November of 2020. So we have, and I was assured by Senate President Feltus that violent criminals would not be released under this. Pretty clear, inconsistent across the state how it's been applied. And this isn't something that's just done in this state, what we're proposing. Utah, Virginia, I know are 2 states that have similar limits on people who commit violent crimes to access bail as easily as we've been doing it here. They have a rebuttable presumption that they should be held. It doesn't mean that they will be held. They have a chance to go to the judge, just like we had before with violations of protective orders. It's now put that back to a few other more egregious cases even. So I'll leave it at that and take any questions. I know you're tight for time and falling behind. I apologize if I went too long.
Senator Carson, you're on mute.
Thank you very much for your testimony, Chief. Are there any questions from the committee? Okay, seeing none, thank you again. Margaret, that's the last person that I have who has signed up to speak. Are there people in the waiting room?
Yes, we do have 3 hands raised.
Okay, let's take them one by one and make sure they identify themselves for the record and who they represent.
Hello, my name is Albert Scher. I am a law professor at UNH School of Law. I represent myself. My opinions are my opinions. They're not those of the law school or of UNH proper. I've been involved in the criminal justice system. This year marks my 40th year of involvement in the criminal justice system in New Hampshire. I was involved in the original discussions, and I testified in front of the House Public Safety and Criminal Justice and Senate Judiciary into all three stages of bail reform in New Hampshire. I was also on both bail commissions that met, and so I've been very involved in this issue from the beginning. I'm not going to. I oppose SB 92. Many others have spoken to issues that matter to me, so I want to correct some things that have been said. There was testimony presented in front of House Public Safety and Senate Judiciary about data. I know that because I presented the data. I presented data about the the rate of incarceration in Hillsborough County Jail for people with bail set at less than $1,000. It is not comprehensive system-wide data. That's not possible given the lack of data collection system to this point in New Hampshire, but I did present that data. Number two, Chief Shiguri is just flat out wrong. The chiefs of police and the prosecutors were not excluded from testifying at the first hearing of the original bail reform bill. In fact, the chief of police testified extensively in and supported the original bail reform bill in front of public safety. And I have talked to at least 2 prosecutors who knew that that bill was being presented, and who failed to appear to testify. No prosecutor was excluded from testifying. No police chief was excluded from testifying. There were, on the second bail commission in particular, there are either 5 or 6 representatives from law enforcement, be it prosecutors or police officers, or people from the Attorney General's office. 6 members of the second bail commission were law enforcement. So in terms of context, I want to offer that to the committee. And finally, I've had, again, in the vein of anecdotal data, I've had conversations with 3 superintendents of the houses of correction over the last 6 to 8 months. And they have said the overall effect since bail reform went into effect is that more violent people are being held in jail rather than less violent people. The reduction in numbers in jail are for people who are held, who had previously been held in small amounts of cash bail, like $500. Basically were held because they didn't have $500, not because it was a serious offense of any sort. So the anecdotal data that I've gathered from superintendents of jails, all of whom were supportive of every phase of bail reform, tells me that the number of violent individuals being held as a function of bail reform has increased. Why? Because rich people who are charged with violent crimes are far more often now being found to be dangerous under the current bail reform statutes. So I offer that those bits of data in response to what I've heard today. It was not my original intent to testify, but I want to correct some of the record as to what's been actually going on. Thank you, and I'm more than willing to entertain questions.
Thank you for your testimony. Are there any questions for the committee? Okay, seeing none, thank you very much for your testimony. Okay, who do we have next?
All right, next we have Robin Malone.
Is there anyone who has not testified yet?
Yes, we have Asma Alhouni also.
Okay, why don't we put Ms. Alhouni through first?
Hello, can you hear me?
Yes, we can.
Yeah, my name is Asma Alhouni. I'm with Rights and Democracy. I am also a certified domestic and sexual violence advocate as well. I am urging the committee members to vote against this bill. This bill is only moving us backwards as a community. We absolutely should not make changes to bail without a thoughtful process that includes the bail commission. What we need is to roll back the penal system that harms, not to expand it with bills like this. This is basically allowing people who are not convicted to be punished without trial. I also want to share that this is also a racial justice issue. For example, the incarceration rate for the Black community or the African American community in New Hampshire is 8 per 1,000 Black residents. The white incarceration rate in New Hampshire is 2 per 1,000 residents. So I'm afraid that the people that could be caught up in this are people of color. The New Hampshire police chiefs, I want to remind everyone, was against HB 556, the same bill that some of you here have said sounded reasonable to you, and they were against that. So, and last, again, I mentioned I'm a certified domestic and sexual violence advocate, and though I don't speak in my organization's capacity, I still want to say that I'm appalled that the police would use women's pain to support such a harmful bill, and I refuse to sit and watch the cause of women's rights to be used to harm people and their lives by forcing people to be held before trial. This is a dangerous bill, and even if you support it, you should at least agree for the sake that for our community, that we need to have the right people, the stakeholders in this conversation as well. So please do not support this bill.
Thank you very much for your testimony this afternoon. Are there any questions from the committee? Okay, seeing none, thank you. Do you want to put through Ms. Malone again and just have her identify herself for the record?
All right.
Good afternoon again, Ms. Malone. I'm going to ask you to be very, very brief because you've already had an opportunity to testify.
Yes, thank you, Madam Chairperson. I wanted to respond to Chief Shigori. It was concerning to basically be called a liar. I did have cases since January 1. It's February. So just to be clear that is an issue. I also want to point out that provision 3 of the criminal mischief statute indicates that all other criminal mischief is a misdemeanor. By saying misdemeanor as opposed to class A misdemeanor, that gives the option of making criminal mischief a class B misdemeanor. Prosecutors know and police know well that when it says misdemeanor, it's automatically a class B. They can file a notice of intent to seek class A misdemeanor penalties, which allows them to go up. However, if it says specifically that it is a class A misdemeanor, they cannot go down. Thank you so much.
Okay, thank you very much for your testimony. Are there any questions from the committee? Okay, seeing none. I take it, Margaret, there's no one else?
There is nobody else.
Okay, I'm going to go ahead and close the public hearing on Senate Bill 92. I am going to put the committee in recess until 3:45, and that way it'll give folks an opportunity to stretch their legs and walk around a little bit. So I will see you all at 3:45, and we will conclude with the last bill.
Yeah.
I hope everybody had a cookie break.
I shouldn't
Had an
have.
opportunity to just get up and walk around a little bit. This next one's going to be a little long as well. And I figured our staff would probably like to have an opportunity to stretch their legs and move around and get something to eat, a snack, or perhaps something. So
Very appreciated, Senator.
yes, and we know Senator French's got to have a cigarette, right? Okay, I think, are we, okay, it's at 3:45. Why don't we go ahead and go live again?
We are good to go, Senator.
Thank you very much, Jenny. We're going to go ahead and come out of recess, and we are going to open the public hearing on Senate Bill 96 and call the prime sponsor, Senator Bradley.
Good afternoon again.
Good afternoon, Senator.
Good afternoon again, Madam Chair and members of the committee. Jeb Bradley, Senate District 3. I'm pleased to be here as the prime sponsor of Senate Bill 96. Senate Bill 96, I was asked to introduce by the governor's office and the attorney general's office. I will let them do the bulk of the testimony on the particular parts of it. This bill, Senate Bill 96, seeks to implement some of the provisions of the Lee Act Commission that Governor Sununu appointed during the summer. And there are some provisions of that Lee Act Commission report that are not included here, but these are ones that there appears to be broad agreement on. I just want to flag two issues. First, there'll be an amendment that will be presented by the Attorney General's office, and that is amendment number 0202. I think it's a technical correction. And second, section 3 of the bill, starting on the first page, lines 13 through 19, may not be necessary. There was a provision, as I understand it, in the Lee Act Commission report that said there should be a memorandum of understanding between school resource officers and police forces. My understanding, as I've been told, is that RSA 18611 already requires that memorandum of understanding. So I'm not sure this section is necessary. So with that, I think you would be best advised to recognize folks from the Attorney General's office. And I would be pleased to work with the committee on this bill and the prior bill to fine tune it in any way necessary. Thank you, Madam Chair.
Thank you very much, Senator. Are there any questions from the committee? Okay, seeing none. Thank you again for hanging in there with us. Next, I'm going to call Senator Rosenwald. Is she here?
Yep, Senator Rosenwald, you're able to speak. You have to unmute.
Got it. Thank you. Thank you, Madam Chair and members of the committee. For the record, I'm Senator Cindy Rosenwald from District 13, most of Nashua. And I'm pleased to be here as a co-sponsor in support of this bill. It represents the bipartisan and important police reforms, each of which have been carefully and thoroughly discussed by the Lee Act Commission and recommended in the commission's final report. I personally applaud the commission's work and the collaboration among its members representing law enforcement, the Department of Justice, Black Lives Matter, the NAACP, and other New Hampshire stakeholders. It will result in much needed data collection about police interactions in New Hampshire and help police departments expand the use of body and dash cams and also extend implicit bias training to judges, among its other reforms. It's also very responsive to the thousands of Granite Staters who peacefully marched and gathered last year to advocate for police reform, including many in my district. And I'm grateful to the many constituents who've reached out to me and urged me to support police reform. So thank you, Madam Chair. I hope the committee will look favorably upon the bill.
Thank you very much for your testimony, Senator. Are there any questions from the committee? Okay, seeing none, thank you again. Let's see, I am looking for, okay, I don't see anybody from the, okay, the chair is going to call Richard Head. Oh, I'm sorry.
Good afternoon, Madam Chair. Did you want to, you said, I'm sorry, do you want to go to somebody else first?
Yes, I do.
No problem.
We called you. I mean, you did sign up to testify. But if I can ask, there is a senator who did
Of
sign
course.
up and I missed her name. So I just want to make sure that I observe the proper courtesies. Okay, can we call Senator Perkins Quokka?
I do not see Senator Perkins Quokka on my list here. Senator, if you are here, if you could virtually raise your hand. Senator Carson, it does not look like she is here.
Okay. All right, why don't we go back to Mr. Head?
Thank you, Madam Chair. Thank you, members of the committee. I submitted yesterday a letter with a proposed amendment to Section 12 of the bill that deals with implicit bias training with the court. The reason behind the amendment is to bring it in line with actual practices of the court. Oh, I'm sorry. Before I begin, my name is Richard Head. I'm the Government Affairs Coordinator for the Judicial Branch. My apologies. The proposed amendment I sent yesterday brings it in line with the practice of the judicial branch in terms of how it goes about doing its training of judges. It also recognizes that for several years now, the judicial branch has been doing implicit bias training for its judges, and in 2020 had a substantial 3-day implicit bias training program done with a consultant that was brought in to assist, and also to recognize that implicit bias training is a part of the new judge training programs that the court system has. So the reason for the amendment is not to oppose the request, but was to bring it in line with the actual practice and processes that the court system undertakes to decide how they're going to perform training, and it simply does not do it through a rulemaking process, but does it through a collaboration between the Supreme Court, the Chief Justice of the Superior Court, and the Administrative Judge of the Circuit Court. I'd be happy to take any questions if there are any. I did, prior to proposing this amendment, speak with Matt Broadhead at the Department of Justice. And although he can speak for himself, it's my understanding that Department of Justice has no objection to the proposed amendment.
Okay, thank you very much for your testimony, Mr. Head. Are there any questions? Senator Khan.
Thank you, Madam Chair. If I might ask a couple of questions of Mr. Head.
Sure.
And thank you for, you're an important part to this hearing. First, on the implicit bias training, I heard the initial first-time judges have the training. There might be ways other than through 541A to develop the rules around that. I respect both of those. It struck me that our definitions and our insights into bias training are going to be something that is an accumulation of information and training and cross-training among various participants in the law enforcement structure. So is that something that as that evolves, that you anticipate an annual training, an annual review? It's my parallel to this might be sexual harassment training, the kind of protocol that the departments and legislative branches go through on an annual basis.
Thank you for the question, Senator. Absolutely. The training that's being done and actually has been done for a number of years and will continue and is going to be done on a regular basis for sitting judges and will remain a part of the program for new judges is, as you suggest, an evolving training as we develop more information and more science behind these issues, that gets incorporated into the training programs that is presented to judges. So it is not just new judges, but it is training that is an ongoing part of the judicial branch's programs and how they perform regular training with the judges, which occurs throughout the year.
Can I follow?
Follow up?
Would it be helpful to add the word annual to the bill? And I'm sorry, I'm referencing, I've got too many screens going. But would it be helpful?
Truthfully, I don't know if it'd be helpful or not. I don't think it would change anything. So certainly if the word annual, I'm just reading the language to see where it would go. To receive, actually it does say annual.
Yeah, it does.
So to receive annual training covering the topics.
Very good. Glad to hear that. Because I'm focusing actually on page 3 right now, and just as a basis for understanding the move from LEAC's recommendations to Senate Bill 96 and other legislation, perhaps it was your office that was responsible for making that translation for the legislative changes, right?
I think that may have been inserted by the Attorney General's office. I'm not, is my understanding, but truthfully, I don't know who actually put that language into this bill in the original version of the bill. My proposed amendment is the judicial branch's proposed amendment to Section 12.
I see. Madam Chair, my questions are next. I wanted to ask about sections 10 and 11 to the bill relative to non-driver's picture identification card. But if that's, Mr. Head, if that's not something that your department placed here, then I suspect it's probably from the Department of Safety, and I don't know where to address that question, but I'd like to do so during the hearing.
Okay.
So it certainly, I'm unaware of who was responsible for putting those sections into this bill. I'm hopeful it'd be one of the subsequent speakers to this hearing.
Okay, thank you.
Okay, I believe Senator Gannon had his hand up.
Thank you for taking my question. It's a newer area for me, implicit bias training. Is that, I'm hearing some people say that there's an assumption that all judges then are biased, or is it just to say to a judge, there's a possibility of you being biased? We want you to look at the possibility of it. Where's the factual data coming from that this is a science?
There's actually a great deal of research and study, and so I did not sit in on the 3-day training that the judges did last year because I wasn't part of the judicial branch yet. I did do the Attorney General's implicit bias training program. That was a couple months ago. And there is a, and maybe some of the subsequent speakers can also talk to this, but what I took away from that is that there is actually a great deal of science relative to how the human mind interacts with people, and the science exists relative to implicit biases and racial prejudices that are not overt and are not easily recognized by ourselves, but exist and should be, a part of any judge's thought process when dealing with a criminal defendant. And in the training as described in the bill is also for everyone involved in law enforcement, not just the judges, because it does affect all of us. But my takeaway from the program that I attended was there is a great deal of science, and there's an evolving science that returning to this topic on a regular basis is warranted and worthwhile.
Okay, thank you.
Thank you.
Are there any further questions? Okay, seeing none. Thank you very much for your testimony.
Great. Thank you for your time today.
Next, we're going to go to Matthew Broadhead.
Thank you, Madam Chair. Can you hear me?
Yes, we can. Good afternoon.
Good afternoon, and good afternoon, members of the committee. My name is Matthew Broadhead. I'm a Senior Assistant Attorney General at the department. I'm the Bureau Chief of the Transportation and Construction Bureau. And in that capacity, I serve as the Chief Legal Counsel to the Department of Safety. In June of 2020, Governor Sununu established a Commission on Law Enforcement Accountability, Community, and Transparency called the LEACT Commission, to develop recommendations for reform necessary to enhance transparency, accountability, community relations in law enforcement. The Attorney General served as the chair of that committee. And in August of 2020, the commission issued a report containing 48 recommendations on improving policing in our state. Many of these recommendations did not require legislation. They have been implemented by administrative action through the Department of Justice, Department of Safety, and also the Police Standards and Training Council has implemented many of the recommended reforms through changes in its curriculum or by seeking to make changes to its administrative roles. However, some of these recommendations did require legislation, and what you have before you is an omnibus bill that in one fell swoop would adopt all but 2 of the commission's recommendations that require legislation. You're still actively working with stakeholders and drafting legislation for the other 2 recommendations. These are important provisions that increase transparency in policing. They provide a funding source to assist local agencies to adopt body cameras, a key recommendation made by the LEACT Commission. It allows the collection of key demographic data from driver's licenses and requires law enforcement agencies to collect and distribute aggregated de-identified data. This will allow the public to glean insight into the details of law enforcement's interactions with the public, but while protecting the identity and the privacy of individuals. I do have, as Senator Bradley had previously indicated, I did have an amendment to offer to add additional language, which I did see it was distributed to the committee this morning. The intent of this bill in sections 9 through 11 was to fulfill the recommendation from the LEACT Commission to have an optional field on the driver's license to allow someone to input their race or ethnicity. And as drafted, the bill only does this for non-driver IDs. This is an inadvertent technical oversight. The amendment adds the applicable field for race and ethnicity to commercial driver's licenses, to enhanced driver license ID, and to regular driver's licenses as well. So it does fulfill the main core recommendation of the LEAC Commission. There's one more minor technical suggestion that I do have on page 4 of the bill. It's lines 2 through 3. Toward the end of line 2, it says pursuant to, and then it lists 3 RSAs. I think that's duplicative and does not need to be in the bill. So I would recommend striking pursuant to RSA 260.21, and then that language up to RSA 260.21b. I think that is duplicative because it does say at the top of that paragraph that collect data from a driver's license or other state issued identification card. So I don't think there needs to be specific statutory sites in there. And in terms of Senator Bradley's suggestion on section 3, I think. I think we'd be open to, there is this RSA 186.11, which provides the duties of the State Board of Education. Paragraph 37 talks about school resource officers. The main thrust of what was recommended by the LEAC Commission was to make sure that those school resource officer agreements are public. So, I'd be amenable to striking section 3, but keeping that last line in section 3, the lines 18 and 19, where it says any agreement to provide law enforcement officer presence within such institution shall be a public record subject to disclosure. So fulfilling that key LEAC recommendation, making those records public, that could either be done by keeping it in this section or by adding it to RSA 186.11. I think either or could work. As for the proposed change from the judicial branch, our office has no objection. Richard was correct about that. So that's all I had. Happy to take questions. I'll just note that I was not a member of the LEAC Commission. So in terms of if you have any specific questions about why something was recommended, I may not know the answer to that, but certainly can address questions related to the language that's in the bill.
Okay, thank you very much for your testimony. Are there any questions from the committee? I see Senator Khan has his hand raised.
Thank you, Madam Chair. Thank you, Mr. Broadhead. And I appreciate that now that I've read the amendment 202, that you've addressed the driver's license issue as well as the non-driver ID. My question, I wonder if you've reviewed the fiscal note that is on the analysis, to the bill.
I have.
Okay. I guess I'd ask if maybe through, well, my observation, Mr. Broadhead, is that it did not address the costs of driver's licenses or instituting a non-driver's license card program. And I guess I'm asking that we pay some attention to that so that it becomes a part of an amended analysis.
I did see that the Department of Safety did offer a note on their body-worn camera and dashboard, but did not provide a fiscal note with respect to the license change. That's something I'm happy to reach out to the state, to the DMV to see if they have any thoughts on that. One thing that I can let you know is this non-driver ID program does currently exist. It's just amending what's recorded on the application and what's contained on the driver's license itself. I do know, in having a discussion with the director of the DMV, Elizabeth Galecki, that there is some concern about the space on the driver's ID in terms of where they would add those additional fields, but she did not indicate to me any sort of concern about the financial impact of that in that conversation. I do know that the commissioner of the Department of Safety is on the call as well. I don't know if he might have any further input on that particular point.
Thank you, Mr. Broadhead. I think that that's the information that I was looking for under that section of the analysis. And, while the body cam information is there, the driver's license information is not. So if we can get that information or through the testimony later today, that'd be great. Thank you.
Are there any further questions from the committee? Okay, seeing none. Thank you very much for your testimony, Mr. Broadhead. Okay, next we are going to have Myra O'Neill.
Myra, I do not see you on our list. If you could raise your hand virtually.
Very good, thank you. Can you hear me?
Yes, we can.
Thank you, Madam Chair, Vice Chair Gannon, and esteemed members of the Judiciary Committee. For the record, my name is Moira O'Neill, and I'm the state's child advocate. I appreciate the opportunity to speak about Senate Bill 96. I submitted written testimony to you already, and so I'll limit my time for just a few key points on items 6 and 7 having to do with the changes in delinquency. Item 6 on page 2 creates a minimum age for delinquency at 13 years. And on this, I have 2 points. In the first, the most practical point, children may not have adequate brain function for competency to understand their actions or the legal process. We've learned a great deal about the length of time that it takes for the frontal lobe of the brain to develop, and how that part of the brain is the center for critical thought and reasoning skills. So restricting such young children from the delinquency statute forgoes the time and expense of competency assessment by a presumption of incompetency based on the science of brain development. And the second point on this is establishing a minimum age for delinquency reduces the harmful exposure to the juvenile justice system itself. The science has demonstrated a high potential for harm with any involvement in the system at all. And in fact, involvement in the juvenile justice system at any stage is the greatest predictor of recidivism. So these children are also more likely to experience depression, anxiety, poor school performance, eventual employment difficulties, and as I mentioned, involvement in the adult criminal system as well. So we've learned that we can do a lot better by children with different interventions. My team and I have worked directly with children whose experiences confirm these points. So one case, we came to know a young girl who was placed at the Sununu Youth Services Center at the age of 12. Since that time, we've observed remarkable maturing in her response to others and to her circumstances, but unfortunately, her risk of recidivism has been realized. We've witnessed in her a withdrawal and poor self-esteem. The longer she remains in the system, the greater the risk that the harms are going to magnify. So her experience exemplifies the need for a system that treats children with an understanding of their needs and the development of capacity at the earliest possible point. And then item 7, also on page 2, would remove certain offenses as a basis for transfer to the Superior Court or treating children as adults. We support this change based on the same understanding of children's brains that I mentioned before, their capacity to learn, and probably most importantly, the potential harm of doing the wrong intervention over time. So a case example here to make this point is a child my team and I came to know at the Sununu Youth Services Center after committing a serious offense at a very young age. Despite the hardship of living at the Sununu Center for a long time, he did mature He did very well in school. He was assisting teachers. He was generally a kind and respectful person who learned from his bad deeds. But after watching that growth and good behavior, we then watched him move on to the adult system when he turned 18 because of the transfer to the Superior Court long before he became the person that he is now. His future really haunts me on a regular basis. So in closing, I just want to also mention a remarkable initiative that's underway to transfer juvenile probation and really the entire system. It's a product of multidisciplinary work, including all branches of our state government and officers of the court. It's chiefly aiming to understand and address children's needs as a means to mitigate any risk they present to the community. So this approach would minimize the focus on offenses and instead figure out how to best help children with minimal exposure to this juvenile system. And I understand New Hampshire may not be ready for this way of thinking as it relates to some offenses at this point, but this bill acknowledges the advances in the field and it provides us an opportunity to learn from small changes. So I encourage you to support the bill. Thanks for the opportunity to speak before you today, and I welcome questions if you have them.
Thank you very much for your testimony. Senator Whitley has a question.
Thank you, Madam Chair, and thank you, Ms. O'Neill, for your testimony and your work on behalf of New Hampshire children. We are lucky as a state to have such a vigilant advocate for children, so I thank you for that. I wanted to ask you if you're aware of the data that also shows that children in the juvenile justice system also have a very high incidence of behavioral health disorders, and if you've seen in your work that that children that do end up in the juvenile justice system do so because of an unmet behavioral health need.
Yes, thank you for that question and the kind words, Senator Whitley. We absolutely see that. And I'm sorry, off the top of my head, I'm terrible with numbers, so I'm not going to make something up, but I can tell you that the majority of the children, particularly those who are confined, detained, or in residential programs, do have some kind of a behavioral disorder. And a lot of that is misunderstood. In the past year, the Sununu Youth Services Center did hire a forensic psychologist. So there is starting to be a shift at trying to understand children's behavior. It's not always mental illness, but it's also not always bad intentions. It's often a communications disorder or some kind of a developmental disability that is the result of abuse, neglect. We see a huge number of children who we refer to as crossover youth. They have been abused and neglected chronically. The system isn't able to restore their families to a better functioning, and their behavior in response to their treatment ends up sort of turning on them, and they become held responsible in the juvenile system rather than their parents being held responsible in the child protective system. So the movement in the field is really to try to understand where the behavior is coming from and how best to treat it. And the idea is that if you can mitigate that behavior, does that mitigate the risk to the community? And if so, then that's where you want to direct your energies. And Senator Carson is sponsoring Senate Bill 94, which is emphasizing a diversion from the system through a careful assessment of kids before the petitions are filed, so we can better understand them. This fits into the broader system of care expansion that we're capitalizing on.
Senator Gannon has a question.
Just a quick question for you. Thank you for taking my question. Were you talking earlier, or were you alluding to restorative justice? New Hampshire not being ready for that? Is that what you were saying?
Oh, thank you for the opportunity to clarify. No, I don't think that New Hampshire is not ready. I think New Hampshire is positioned to be very ready for it. But I think that in the conversations that we're having around certain offenses that children may be accused of, there's still some disagreement about whether or not you would still focus on children's needs and not on the particular or offense or the level of offense. I mean, in a perfect world, we would ignore the offense and just look at the child's need. That's what I don't think New Hampshire is quite ready for, which I think is within reason, because this is a lot of change happening to a system.
Thank you.
Okay, are there any further questions? Okay, seeing none. Thank you for your testimony, Ms. O'Neill.
Thank you so much.
Okay, next we're going to call Joseph Hobecki.
Good afternoon, Madam Chairman. Can you hear me?
Good afternoon. Yes, we can.
I should say Chairwoman, I'm sorry, and members of the committee. I appreciate the opportunity to speak before you today. My name is Joe Hobecki, and I'm the Chief of Police in Hollis, New Hampshire. And I also serve as the first Vice President of the New Hampshire Chiefs of Police Association. Next week, February 11th, I'll celebrate my 20th year in New Hampshire law enforcement. So happens to be my daughter's birthday. And I can tell you that it is the honor of my life to serve in this honorable and noble profession. And I can assert to you that I was happy to have served as a member of the LEAC legislation work group with Attorney Broadhead and other stakeholders who share a genuine and common goal of meeting the recommendations of the LEAC Commission. This bill includes some of those important recommendations, and I feel as though the content included within the legislation will help ensure transparency and fairness within our system while demonstrating the incredible work that the dedicated men and women in New Hampshire law enforcement do on a daily basis. So today I'm here to testify in support of SB 96 as a chief and as a member of the Association of Chiefs of Police. But I do have some recommendation on some proposed amendments. On paragraph 3, we've already spoken to that. Senator Bradley and Attorney Broadhead mentioned that this paragraph is somewhat duplicative to what is already in statute. However, and I speak for the association, that we fully support the addition of language to RSA 186.11, section 37, I believe, that the MOUs for these school resource officer programs be made public. Additionally, I read a bill earlier today, I believe it's HB 108, that has very detailed content relative to the structure of school resource officer programs. My second recommendation deals with dashboard cameras, and it's a very minor tweak. I would just recommend that we change the word dashboard to in-car cameras, just because it's not always a dashboard camera. So that's just one recommendation I have for the language of the bill. And then the last part relates to data collection. So I worked with a few stakeholders on this, including the ACLU. And I can tell you, I'm a chief that genuinely supports data release or release of demographic information relative to citizen contacts. However, I think that the language of this legislation as written can be problematic for a few reasons. First of all, if we try and populate town of residents for every traffic stop and citizen contact, there is just simply no way that records management systems can do that. And as such, that would require manual entry for all of persons stopped for their town of residence. So for us as a small agency, we have 15 officers. That's about 5,000 traffic stops a year. That doesn't include arrests. It doesn't include field interviews. What would need to happen, because our records management system just doesn't populate that specific information, is we would need to go through and manually compile that information. And that would take months to do that. And that would tie up considerable resources that we're just not staffed appropriately to handle. And I think if you speak to other law enforcement agencies throughout the state, you'll find that to be true as well. So I think that we need to look at the language of this bill. Again, I wholly support, and I can't express that to you enough, that this information should be public. We already do it. We're a nationally accredited agency, so it's actually a requirement for us to do that. And it's a public document, which is right on our website. So I am more than willing to work with stakeholders, including the ACLU, to kind of tweak the language of this to make it workable. But having said that, I do see that there will be a need if the legislation stands as is, the language of it, to have a state database to collect this specific data, such as percentages of citations for persons of color, minority communities, because simply stated, our records management system is just not equipped to populate that data. There's a lot of things it does do, but it just doesn't do that in order to equip our system with that would be incredibly costly. And to be frank, I'm not even sure that the company would do it. So certainly I would be more than willing to work with the committee and other stakeholders to come up with some more workable language. Again, I support this wholly, but I do think we need to fine tune this a bit. And then we also need to look and consider at the fiscal burden that collecting this data would result in. And so with that, I'll conclude my testimony and open it up to any questions that any of the committee members may have.
Thank you very much for your testimony. Are there any questions? Senator Khan.
Thank you, Madam Chair. Chief, thanks for your 20 years of service. Happy birthday to your daughter.
Thank you, sir.
But it's you were a member of FLIAC, right?
No, I'm on the legislative work group for LEAC.
Okay, thanks for that clarification.
Yes, sir.
I was wanting to ask about in-car cams. And your terminology for it was not dash cam, but to call it?
In-car cameras or in-car videos. It's really kind of nitpicking, but I think if we're going to stay true to what they are, we should label it appropriately.
Thanks for your view on that. That might be hard to swim against that current. But the other question, has Hollis purchased any in-car cams for officers?
Well, it's funny you mentioned that. So in 2016, we were one of the first agencies in our area, at least, to use body cameras. And so this year marks the end of our service agreement with the current vendor. So just last week, we updated our systems that includes the installation of in-car camera systems with body cameras. So it's an integrated system. So each of the patrol vehicles have in-car cameras, and each officer, including myself, because I think that's important, have body cameras as well.
Is it your view that
follow up?
Thank you, Madam Chair. Is it your view that the in-car cams are beneficial not just for defendants, but also for law enforcement and protection of your officers?
Absolutely, and I'll answer it two ways. It ensures transparency, and to be frank, I would not operate an agency without body cameras and in-car cameras at this point. It's a different time for policing, and I think it's very important that we use the technology and tools available to demonstrate and build the trust and legitimacy of our agencies.
Thank you, Chief.
Yes, sir.
Okay, are there any further questions? Senator Whitley.
Thank you, Madam Chair, and thank you for taking my question. Just sort of going back to the data collection piece, because this was such an important part of the LEAC Commission and the work to improve transparency. I'm wondering, if just an update to the software that the state uses would help alleviate your concerns.
So the problem is that each individual agency uses their own records management system. We use a company called IMC, and it's probably one of the more popular records management systems in the state that's used by a number of agencies. And unfortunately, the capabilities are just not present in order to populate the data that's listed in the specific language of the legislation as it stands, which is why I mentioned that I feel like we should amend this to be workable until maybe down the road we can implement a statewide system like Vermont uses in order to populate this data that kind of meets the expectations of what was originally written in the bill. In order to modify records management systems, as I mentioned, I'm not even sure that they would do this, and it would be a significant cost. We pay about $17,000 a year just for licensing and fees for our records management system. And any time that you tweak or add features, it costs more money. And so that's my concern, is that, you know, the way these systems are constructed at this point, it just does not allow us to populate this information through some of the metrics that are collected within the system. And as such, we would have to manually populate this. And to be frank, I'm not, if this bill passed tomorrow, I'm not sure I would be able to meet the requirements of it. Hope I answered your question.
Okay, are there any further questions? Senator French?
Thank you, Madam Chair, and thank you, Chief. I have a question about this collection data process. So it's including all motor vehicle stops that did not lead to a citation. Do you think, do you think possibly that would increase the amount of citations given, just so they wouldn't have to fill out this report?
Well, the way records management systems work, Senator, is anytime an officer conducts a stop, regardless of the disposition of the stop, they have to enter mandatory fields within the RMS, the records management system. So if I conducted a stop for you because I thought your inspection sticker was expired and it turns out I misread the number, I would still have to populate information in what's called the CN number. And that includes a requirement to complete demographic information such as race, ethnicity, gender, et cetera, which is why there was a push for us to get ethnicity and race on driver's license, because I don't want to put my officers in the very uncomfortable situation where they're on the side of the road and they're trying to ask someone what their race is or what their ethnicity is. Oftentimes, if they don't know, to be frank, Senator, they have to guess. And so there is a margin of error with the data. So I think by adding, race and ethnicity to driver's license, although it's optional, I think it will help reduce that margin of error.
Thank you.
Yes, sir.
Okay, are there any further questions? Okay, seeing none. Thank you very much for your testimony this afternoon, Chief.
Thank you, Senator Carson.
Okay, next we're going to call Joseph Lascaz.
Thank you, Madam Chairman. My name is Joseph Lascaz, and I'm a New Hampshire native and resident, and I will be representing the American Civil Liberties Union of New Hampshire in full support of SB 96. As a Smart Justice organizer for the ACLU, New Hampshire, my work focuses on criminal justice and police reform here in our state. This includes working with the Department of Corrections, Department of Safety, several New Hampshire police departments, as well as Police Standards and Training Council to formulate and advance effective reforms that will benefit our New Hampshire communities. This past summer, I served as an appointee for the ACLU New Hampshire, the Governor Sununu's Commission on Law Enforcement Accountability, Community, and Transparency. This commission had many diverse and differing perspectives. However, there were many transformational recommendations that we came to consensus on, and this legislation is one of them. I fully support this legislation because enacting it will strengthen New Hampshire's credibility as we start to gain momentum towards being a more transparent state. Another crucial element of this bill is that it will address a weakness that New Hampshire currently has, but we don't need to, and that's the lack of comprehensive data around law enforcement in New Hampshire communities of color. I think everyone on this Judiciary Committee would agree that wise and informed decisions are based on facts, and if we wish to better our current system, then we're going to need to have data to analyze that and see how the system is currently working. I wanted to speak about the MOU concern that was brought up earlier. The reason why this recommendation was put forward as is transparency is in the name of this commission, and the MOU needed to be public. That was the reason we had supported it. Many concerns had come in from Granite State parents about, they send their children to our schools, and why would they not be able to know what the MOU states? So that was why that concern was trying to be addressed there. And regarding the implicit bias recommendation, this recommendation was set sort of as a floor for the training to be at least 2 hours, with the option of increasing if necessary. And that's reflected in the language when you see that it says it could be updated by the Chief Justice as necessary. When you look, I wanted to also respond to a concern by Senator Gannon earlier about the implicit bias and training, and whether or not if it was real or not, if there was a science behind it. And I just wanted to say that the truth is that everyone is inherently biased. And this was also reflected in the New Hampshire Supreme Court case for State versus Ernest Jones, where race was an element that could be added to how decisions were made. But biases are formed from experiences, and experiences happen, to everyone. So it's, the best way I can say it would be if you ever purchased a product that didn't work to your expectations, the next time you want to buy something, you would probably purchase something different. You would have a bias towards that. But the problem is when those biases are occurring in the system, that's allowing it to be human behavior and is controlled by racial implicit biases. That's when you have community members that are being directly impacted by an abuse of the justice system. So as a member of the Governor's LEAC Commission and an advocate for marginalized community members across New Hampshire, I support this bill, and I ask this committee to stand with New Hampshire and their call for systemic change by voting ought to pass on SB 96. Thank you for hearing my testimony, and I'm happy to answer any questions this committee may have.
Thank you very much for your testimony this afternoon. I see Senator Gannon has his hand raised.
You're
Bill?
on mute, Senator.
You're on mute, Bill.
I'm sorry,
there
Joe.
you go.
I got to get better with the technology. Where can I get that sweatshirt and a XXX?
I can get one to you. We could talk offline.
Okay. Give me a call sometime. I'll buy one.
All right.
Thanks. Have a good day.
Yeah.
Okay, are there any further questions? Okay, seeing none, thank you very much for your testimony this afternoon. The chair is going to call Mark Morrison.
Good day, Madam Chair and fellow committee members. My name is Mark Morrison, and I'm speaking to you today on behalf of the New Hampshire Police Association in my capacity as president. I've been a certified law enforcement officer for 22 years, and I'm currently a lieutenant with the Londonderry Police Department. In my capacity as president of the NHPA, I was privileged to be part of the LEAC Commission this past summer. There were many hearings and hours of discussion on many issues dealing with New Hampshire law enforcement, and it's good to hear some of my fellow commission members' voices as they testify today. This bill represents some of those recommendations made by LEAC, and the NHPA is proud to support them. My testimony was going to touch on what has already been covered in some of the amendments noted by Senator Bradley. So I'll leave those amendments to stand on their own. And I would also support the recommended changes from Attorney Broadhead, adding the line about the MOU being added to RSA 186.11. Lastly, I would suggest what may be an edit to the language of the data that is to be collected and sent to PSTC. I was one of these, supporters of capturing race on the New Hampshire driver's license to make capturing this information easier and more efficient for law enforcement.
And it would remove the possibility of that uncomfortable situation of making a race determination out on the road or in non-custodial situations that could, cause a strain between the officer and the individual with whom they are dealing. The addition of adding race to the license as well as a non-driver ID would more easily allow for the capture of that information while not forcing that negative interaction with the officer on the street. So I guess my concern is clarifying the language, because race and ethnicity is hyphenated or connected with a slash and seems to be being used synonymously. I would just recommend that we use race, as that was the recommendation for the LEAC Commission. And this is also just taking into account the concerns brought up that I remember by the Department of Safety on the physical space in the license that would allow for that data collection to be made on that license and tabulated later. So that is the end of my concerns. And again, I would just like to highlight our support for this recommendation and this legislation that has been put forward, with our respective partners in this area. Thank you.
Thank you for your testimony. Are there questions from the committee? Mr. Morrison, I would just like to make sure that I understood what you were asking for when you talked about the use of race and ethnicity on a identification card, which the legislation says in both instances are optional. Are you saying that you think we should definitely capture race and not ethnicity?
I think capturing both could be a challenge for the Department of Safety, especially considering, how varied, some sort of ethnic backgrounds can be. I think race is, sort of a smaller group of categories to pick from, and it would just, be more sensible as far as that goes. I'm certainly not against capturing, whatever information, but to be able to comply, with this statute, to be able to comply with the collection of this data, I think it would be, very helpful to certainly have race, and that obviously is what the recommendation for LEAC was.
Okay, thank you very much for that clarification. Senator Whitley has a question.
Yep. So it's a comment or a question about the race ethnicity collection, because I think it's important. Clearly, in the LEAC discussions that we wanted to capture race, but I think the ethnicity piece might be important also because it captures Latinos maybe that wouldn't be characterized or wouldn't be captured if we just collected race. So how would you collect data on Latinos if we excluded the ethnicity portion?
Well, again, that's part of the problem. I'm really not the one to answer that. And, if we have, like, I checked our record management system, and we either have Hispanic or non-Hispanic, but you have a lot more categories, for race. So it's just a challenge. It's a statistical challenge. And again, in order to try to comply with this, I guess my point is to make it as easy to comply and most beneficial, at the same time. And I only bring up, this clarification on this language because in our LEAC report, it was very specific to just race, and ethnicity wasn't listed in that recommendation. And it's not to exclude it. I'm just looking for, I think, what just would be some easier clarification so that we can all be on the same page and follow it.
Yeah, so I think that section could be addressed. I want to make sure that we're not excluding, data collection for any community of color that's been impacted in the past.
Yeah, and certainly that isn't the point of my recommendation. Again, it's simple, data collection, and we just want to make sure that we can comply and put that information forward.
Okay, thank you. Are there any further questions? Seeing none, thank you very much for your testimony this afternoon.
Thank you, ma'am.
Next, we have Ken Norton.
Thank you, Madam Chair and members of the committee. My name is Ken Norton, and I'm the Executive Director of NAMI New Hampshire, the National Alliance on Mental Illness. And I thank Senator Bradley and Senator Rosenwald for sponsoring this bill. I was really honored to be a part of the LEAC Commission. While obviously there's a lot of issues relative to race and implicit bias that were discussed by the commission, there's a lot of overlap with law enforcement and mental illness. And we've already heard testimony regarding juveniles from Maura O'Neill, but high rates of arrest and incarceration of people with mental illness, the crisis response for law enforcement involving people with mental illness, and perhaps most disturbing is that 45% of the officer-involved shootings in New Hampshire involve people with known mental illness, according to the Attorney General's office. So it was an honor and a tremendous learning experience to be a part of the committee. I do support the amendments proposed by Senator Bradley and Attorney Broadhead. And I do caution making any other significant changes to the legislation. The amount of listening and compromise and work that went into these recommendations was extraordinary. I've served on a lot of commissions over the years, but this was definitely unique. And with that, on behalf of NAMI New Hampshire and as a member of the commission, I ask you to vote Senate Bill 96 as up to pass, and I'd be happy to answer any questions.
Thank you very much for your testimony this afternoon, Mr. Norton. Are there any questions from the committee? Okay, seeing none, thank you again.
Thank you.
The chair will call Will Stewart.
Thank you, Madam Chair and members of the committee. For the record, I am Will Stewart, the Executive Director of Stay, Work, Play New Hampshire. We're a statewide nonprofit whose mission is to attract and retain more young people here in the Granite State, and I'm here today to speak in favor of Senate Bill 96. Attracting and retaining more young people is critical to the future of our state. And as you may know, New Hampshire is the second oldest state in the country with one of the lowest unemployment rates. On top of this, we're the #1 exporter of high school graduates seeking a four-year degree, with some 62% of these graduates leaving the state every year. Some eventually come back, but many don't. So in short, New Hampshire needs all the people we can get in general and all the young people we can get in particular. Our businesses need workers and customers, our towns need volunteer board members, and our nonprofits, churches, and civic clubs all need volunteers to accomplish their vital missions, without which our communities just can't function. So about 3 years ago, Stay, Work, Play commissioned a survey that to collect data on why young people stay in and why they might leave New Hampshire. And one of the reasons we found that young people might leave is due to a lack of diversity here in New Hampshire. And we heard this over and over again last fall and winter as we talked to young people in 9 locations across the state as part of our Policy and Pints series. Indeed, New Hampshire's lack of diversity was a top 3 reason cited for young people potentially leaving the state. So as a result of these findings, increasing diversity, equity, and inclusion here in New Hampshire has become a policy priority for Stay, Work, Play. And it's for this reason that we support SB 96, which, as we heard, is a bipartisan bill that seeks to increase trust in the judicial system as a whole and with law enforcement in particular. And both of these are necessary if we want to attract and retain more people of color here in New Hampshire. So thank you for your attention and for your consideration in supporting Senate Bill 96.
Thank you very much for your testimony, Mr. Stewart. Are there any questions from the committee? Okay, seeing none, thank you. The chair will call Ani Malachi.
Good afternoon, and thank you very much for recognizing me, Madam Chair. My name is Ani Malachi, for the record, and I am the Executive Director of the Commission for Human Rights here in the state. However, I am giving testimony today not representing the commission, but or the Human Rights Commission, but as a member of the LEACT Commission. I had the distinct honor and immense pleasure to spend 2.5 months with an amazing group of people. It was certainly a labor of love. There was a lot of heavy lifting. And as Joseph Lacaze has testified, and Lieutenant Mark Morrison has testified, and also Ken Norton from NAMI has testified. It was a very unique opportunity for us to take something that was a very stressful topic and to really look at it, take it apart, law enforcement, transparency, and how all of this relates to the community. And we spent many hours debating and having conversations, receiving testimony from members of the commission, as well as those from outside of the commission on a variety of topics. And what you see before you put together in SB 96 is an omnibus version of a great many of those recommendations that we put together. And I believe there were 49 in total. So that was a lot. I am giving my support to SB 96, and I would appreciate if you all would vote ought to pass on this piece of legislation. I support the amendments that were discussed previously, so no need to go back over those. But one of the things, and this has become a bigger topic, and this was on my notes before we actually started discussing it, but the area of race and ethnicity on the driver's licenses and ID cards. And that was one of the things that I really discussed a lot and brought up in my line of questioning with several people who were giving testimony in terms of data collection. And Lieutenant Morrison has spoken very eloquently about that, as well as Mr. Lacaze. If you don't have it on the identification for someone, then yes, law enforcement has to guess. And even if it's a positive interaction, the individual, they're ready to go. When the interaction is done, you're ready to move on and resume your day. If it's a less than positive interaction, and it may not be the fault of anyone, it could just be a bad day, pick the person, then how do you then at the end of that go, oh, and by the way, how do you self-identify so that you can put that accurately? And data collection is important. And maybe in further discussions as we look to the DMV to sort out how this takes place, if there's a variety, to Senator Whitley's point, if there's a variety of ways in a particular cultural group or ethnic group as to how they self-identify, then obviously there has to be some consensus on what those identification markers would be. And then maybe it's something as simple as an alphabet that makes it easier so that you have a one-letter space. And I understand that it's premium space on a driver's license or an identification card, but maybe there's a way to assign a single alphabet so that you can deal with race and ethnicity. Because in my in my classes for my master's degree, one of my professors pointed out that race is primarily a misnomer, and it's our ethnicity that is more accurate to who we are as individuals, and can speak more specifically to who we are. Because you have some, the example that Senator Whitley gave in terms of people of Hispanic or Latin American descent, if some consider themselves to be white, some don't. So how do you account for the varieties of self-identification? So not that that's something to waylay any testimony here, not to be argumentative at all, but just putting an idea out there. Maybe it's as simple as an alphabet to solve that. So I thank you all for giving me this time to speak. And I appreciate my opportunity to have served on the LEAC Commission, and I'm available for any questions that you may have. And I thank you all very much.
Thank you very much for your testimony. Are there any questions from the committee? Okay, seeing none, thank you very much. That's all that I have. Who has signed up here, Margaret? Are there folks in the waiting room?
We do have Joseph Lacaze has his hand up, Julian Jefferson, and Helen Hanks.
Okay, all right, why don't we get Ms. Hanks first? And I would just like to announce to the committee, I got a text message that we're going to be losing a couple of our members at 5 o'clock because they have another meeting to go to. So I just would like people to be aware of that. So why don't we hear from Ms. Hanks?
Good evening, honorable members of the committee. My name is Helen Hanks. I'm the Commissioner of the New Hampshire Department of Corrections and have been intrigued and invested in the conversations that's been occurring since 1. I'm here in support of Senate Bill 96. I think it does a lot with regard to making adjustments that both inform what ultimately could result in incarceration and understanding patterns across systems. I'm also here to ask consideration on page 1 and 2, specifically new section 4, that the reference to local in front of law enforcement, that there's a consideration to delete that reference to afford agencies such as the Department of Corrections, a law enforcement agency, we might need an opportunity to enhance an already existing project we have to deploy body worn cameras. So it's just a polite ask as your consideration of this bill to provide a broader opportunity for other state law enforcement agencies who are generally funded, if this is going to be a federally funded fund, the opportunity to leverage those dollars. And I will not take any more of your precious time, ma'am.
Thank you very much for your testimony, Ms. Hanks. Are there any questions? Seeing none, thank you and have a great evening.
You too.
Next we have, is it Mr. Jefferson?
Yes.
Okay.
Can you hear me, Senator Carson?
Yes, we can, Mr. Jefferson.
It is so good to be in front of you again and other members of the committee. I am here in support of SB 96. I also keep my comments very brief. I was a member of the Liat Commission, and I just want to say and echo all other fellow commission members that it was an honor and a privilege, and it was something that I think New Hampshire did very well. You know, we took a very difficult subject, and the governor put together a broad coalition of stakeholders and really dived into the issue. So we didn't have a reactionary response. We had a very thoughtful, deliberate response that came out with some universal recommendations that you see in front of you. I also had the privilege of working on the legislative working group along with Chief Hobecki and others to carefully draft some language to put in front of you. And I am fully in support of the bill. The one comment I would say in response to the race and ethnicity concern is I would be supportive of having one field that is just for race, as long as one of those races is Hispanic or Latino, to Senator Whitley's point. Doing a quick Google search, there's sort of two schools of thought that, you know, initially Hispanic or Latino was never listed as a race or ethnicity. A lot of governmental organizations are listing that as a race and ethnicity. So if it is going to be just one field, and I see the practicalities of that, I think the legislation needs to specifically put those 6 universal races there, of which Hispanic and Latino are one of them. And I think that might be a way to solve the problem, but still stay within the intent of what we're trying to do. Thank you so much for your time, and I will take any questions.
Thank you very much. I believe Senator Khan has a quick question.
It is quick. You must have dealt with the question of multiracial profiles, and how did you, what did you arrive at there?
You know, that is a really good question, you know, especially in our country that is so diverse. There are a lot of biracial families and a lot of biracial children. And I don't think there's an easy answer to that one. I think we shouldn't let the imperfect get into the enemy of the good. And I think we would just leave it at the 6, understanding, you know, that, you know, biracial people, you know, may, you know, identify as one thing or the other, or optional. And I think that's also very important that optional requirement stays in there, because if people don't want to identify, they certainly shouldn't have to. I think a lot of people will, because a lot of people see the value in keeping this data. So that would be my answer. Keep it at the 6, understanding that, you know, that is going to leave out biracial components.
Thank you. Thank you for your testimony this afternoon, Mr. Jefferson.
Thank you.
And finally, we will call Mr. Laskarskin.
Okay, and we also do have another hand up, John Skippa.
Thank you for allowing me to testify again. I just will keep it very brief. I just wanted to address a concern that had been brought up by Chief Hobecki around the addresses, and we do hear his concern, and we are happy to continue working with him as well as this committee on addressing it. But we felt that the address was necessary because of a thematic concern that we kept receiving from law enforcement over how we were interpreting racial disparities that were reflected in reports that we had requested from various legal departments across New Hampshire. And what it was whether or not an individual, if there really was disparities in the system because an individual, their residence was in New Hampshire or out of state. So in order to address that, we felt that that was necessary. This is something that would be provided on the driver's license. But like I stated, we would be happy to continue working with Hobecki and this committee on figuring a solution out. And thank you.
Thank you very much for your testimony. Are there any questions from the committee? Okay, seeing none. And let's move to Mr. Skeppy.
Thank you, Madam Chair, and thank you, committee members. For the record, my name is John Skippa. I'm the Police Academy here in New Hampshire and Director of New Hampshire Police Standards and Training Council. I have 32 years of experience in New Hampshire law enforcement and was tremendously honored and privileged to be a member of the Governor's LEAC Commission. This bill that is proposed codifies some very thoughtful changes that came from an intense amount of work from the LEAC Commission. And I'm very proud as I look at this bill as it's proposed. I think it reflects a lot of support on the work that was put in by the LEAC Commission. In support of Senator Bradley and Attorney Broadhead's suggestion on new Section 3, I would concur, and in support of that, specifically, the governor's mandate, his executive order under 13C, my agency was mandated to work with the Department of Education and a number of stakeholders to develop a model memorandum of understanding that could be used for any community and police department to clearly define roles and expectations of a SRO. In support of that, that MOU has been completed and it is posted on our website for use throughout the state of New Hampshire. And it speaks directly to a number of concerns that were brought up during the LEAC Commission. And I just wanted to offer that in support of striking number 3 and then adding the transparency piece to RSA 18611 as it's already been suggested. The other piece that I would speak to is, as the Director of Police Standards and Training Council, we certainly stand ready to move all of these LEAC recommendations forward, and specifically to the data collection. We are presently working with a company to develop a record management system and learning management system that would be used specifically to regulate certifications of police officers and making sure that they're receiving appropriate training. And this would be a statewide initiative. And we're in the middle of working with a vendor to develop that right now. I stand ready to speak to that vendor. And this might be a little bit after the fact since we already kind of cut the deal. But in terms of developing a statewide data collection system that speaks to this bill as it's proposed, this may be an option. And so I just wanted to provide that information to the honorable members of this committee. And I stand ready to work that forward if they saw value in me attempting that. I have nothing further, and I stand ready for any questions that any of the honorable members would have.
Thank you very much for your testimony. Are there any questions from the committee? Okay, Senator Khan.
And thank you, Madam Chair, Mr. Skippa, if you could share the information that you received from your vendor, I think that would be helpful just to put some parameters around some of the undefined implementation costs that there might be to this bill, which I support. I'm a co-sponsor, but I think there's a little bit more information that we need to understand implementation costs. So thanks for your help.
Absolutely, Senator Khan. Do you want me to forward that information directly to you, or what would be the best way to do it?
No, I think if you can mail to the committee so that everybody gets it and the clerk can put it into the file. Thank you.
Very well, sir.
Okay, are there any further questions? Seeing none, thank you very much, Mr. Skippa. You have a great afternoon. Okay, seems like we are finished. I'm going to go ahead and close the public hearing on Senate Bill 96. I'd like to thank all of you for hanging in here this afternoon. A lot of things to think about. So I will entertain a motion to adjourn.
So moved.
Moved by Senator Whitley, seconded by Senator Khan. I will call the roll. Senator Khan.
Yes.
Senator Whitley.
Yes.
Senator French. Senator
Okay,
French.
yes, go ahead.
Okay. Stay on, Senator.
I was like, oh my God, what happened? Senator Gannon
Yes.
and Senator Carson, yes. Everyone have a great afternoon or evening, and we will be speaking soon. Take care, everybody. Bye-bye.